All right, so we'll call the meeting of the Board of Appeals to order for September the 13th, 7:35 PM. First on the agenda is the Pledge of Allegiance, if you'd stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'm glad no one took a knee.
Right.
Yeah, I just said that. No one took a knee. So proud.
All right, we have a lot to do tonight. A couple of things we're going to just do out of order to help some folks along. Next on the agenda is the acceptance of minutes, but we have to need to move to table that because we don't have the minutes
So moved.
ready just yet. Second? All in favor? All right. Next, we have committee reports. Osgood Selectmen Committee, Selectmen Osgood Committee.
So we're going to set up our meetings again, and the next meeting is a tentative schedule for 9/27, which is a Tuesday, and the location is still to be determined, and the time. So if you look at the website, that should be updated soon. If anyone wants to go, public, always welcome to join, and you and I will be there probably. That's it.
Excellent. Any discussion? Hearing none, we will move along. We're going to go a little out of order, just a couple of new hearings that aren't taking any action tonight, but one we need to open the public hearing on. I'm going to do number 9 first, which is the petition of variance from Table 2 of Gerald Becker, care of Donald Bornstein. So we can
Open it, Mr. Chair.
open that hearing.
Notice is hereby given that the Board of Appeals will hold a public hearing at the School Administration Building located at 566 Main Street, North Andover, Massachusetts, on Tuesday, September 13th at 7:30 p.m. to all parties interested in the petition of Gerald, I'm going to go with Becker, and care of Donald F. Bornstein, Esquire, Johnson & Bornstein, LLC, for property 271 Stevens Street, map 95, parcel 008, North Andover, Mass. 01845 in the R3 zoning district. The petitioner is requesting variances from the R3 zoning district, section 4.121 of the zoning bylaw, subdivide one lot into two lots in accordance with Table 2, summary of dimensional requirements, variance lot 1. Lot area R3 required 25,000 square feet, proposed 16,025 square feet, variance needed of 8,975 square feet. Table 2, summary of dimensional requirements, variance lot 1 required front setback 30 feet, proposed 9 feet, variance needed 21 feet. Table 2, summary of dimensional requirements, variance lot 1 required front setback 20 feet, proposed 6.4 feet, variance needed 13.6 feet. Application supporting materials are available for review at the Office of the Zoning Department located at 1600 Osgood Street, North Andover, Mass. Monday, Wednesday, and Thursday from the hours of 8 to 4, Tuesday from the hours of 8 to 5:30, and Friday from 8 to 11:30 by order of the Board of Appeals, Albert P. Manzi, Esquire.
Okay, we have that notice read. Now we have a letter from Attorney Bornstein dated September the 1st, requesting to continue the matter to the next regularly scheduled meeting of October the 11th. I believe we have a time waiver filed. So with that being said, we won't hear any evidence tonight. We would just hear a motion to continue to the next.
Motion to continue to October 11th, Mr. Chair.
Second? Second. All in favor?
Aye.
Aye. Okay, that stands continued. The next one, we're going to go out of order again. Number 7, then we'll get back to our regular order. I understand there's a bit of a daycare situation, so number 7, right, a new public hearing. The petitioner is requesting a special permit of Keith and Amy Harley for the property at 360 Winter Street.
Notice is hereby given that the Board of Appeals will hold a public hearing at the School Administration Building at 566 Main Street, North Andover, Massachusetts, on Tuesday, September 13th, 2016, at 7:30 p.m. to all parties interested in the petition of Keith and Amy Harley for property address 360 Winter Street, North Andover, Massachusetts, 01845, map 104.A, parcels 0012, North Andover, Mass. 01845, in the R1 zoning district. The petitioner is requesting a special permit from 4.121 and 4.121.17 of the zoning bylaw, which is a family suite in the R1 zoning district, is required from the Zoning Board of Appeals. Application and supporting materials are available for review at the Office of the Zoning Department located at 1600 Osgood Street, North Andover, Mass. Monday, Wednesday, and Thursday from the hours of 8 to 4, Tuesday from the hours of 8 to 5:30, and Friday from 8 to 11:30 by order of the Board of Appeals, Albert P. Manzi III, Esquire.
Okay, so we have a public hearing open. Welcome.
Thank you.
Thanks for coming. So tell us a little bit about your project.
Sure. Well, I'm looking to convert what is currently a first-floor master suite into a family suite for my parents. The property has one bedroom on the first floor that has 2 bathrooms that are currently part of it, plus an office space, and a room that's kind of exclusively for a vanity. We're looking to take where the vanity is, push back one of the closet walls to about 24 inches, and create a small kitchen in that space, and use the office space, take out one closet, and have that be their dining space. Then they'll have the master bedroom as their bedroom, living room area. In order to segregate their own space, we would just put in a doorway in the hallway that currently goes down to the master suite. And upstairs, we're left with the other bedrooms for us and the kids.
All right, so you're staying within the footprint of the existing
Yes.
structure, right?
Yep.
So there's some plans here submitted by Mr. Batting. Yeah, please.
There's also a letter from your parents
Yes.
in here as well that you might want to,
Where's the letter? Did I miss it?
okay, it's the first one.
Oh. All right, just give me a second. To whom it may concern.
They
This one?
couldn't be here tonight, they were on a trip.
Oh, okay. All right, we have a letter dated August the 16th to the zoning board, received September the 6th, asking us that we grant the request of Amy Harley for a variance. She says variance, but you're not looking for a variance, right? It's just a special permit.
Right.
According to the bylaw, which would allow her to create a family suite out of the master suite for the first floor home at 360 Winter Street. They found it difficult to maintain their summer home and have decided to sell their property in Connecticut. Okay? Invited us to move there in the household. Okay, so this is signed by your parents. So, did the building department explain to you how the family suites work
Yes.
in terms of,
Only for a direct relative and a parent or a brother or sister.
Sure. Right.
And that it has to be inspected annually and can't be rented out. Yep.
Okay. Any discussion? Looks like a fairly straightforward application from what I can see. Nope. Any discussion points? No?
I guess I just have a personal curiosity
All right.
as to why you're doing this.
My dad had a stroke 4 years ago, and it's become noticeably harder for them to maintain their, they have a place that they're at in Connecticut.
I guess aside from the personal points, I'm just trying to figure out like maybe the question isn't relevant, but I guess I'm just trying to understand why you would impose this restriction on your property, making it a family suite as opposed to just.
Because they're doing the right thing.
Yeah, to answer your question,
Yeah.
we recently bought the house knowing that it was more space than we actually needed for us. And in purchasing the house, we knew that it afforded extra space for her parents to have, an in-law suite. So that's, I don't know if that gets to what you're looking for.
Is that a requirement?
Because there's a kitchen there, so what they're doing is they're
Oh, the
actually
kitchen.
doing the right thing and providing, and making the permit for that, even though they're not doing an addition.
Yeah, the kitchen.
It should, I mean, this is an example of what should be doing,
Right.
you know.
Understood.
I mean, because they can certainly, without anyone knowing, do this and, you know, and just add a kitchen later, like, but again,
I didn't realize that was the kitchen was the
Yep.
problem. Got it.
Yeah,
Okay.
we're adding a second kitchen to our household.
Got it, yeah, thank you.
It's all existing square footage.
Yes.
It's only 24%, which is guidelines.
Yeah,
So we're covered there.
certification there, right?
Yeah, we're covered on
Those
that.
letters, guys.
And it's stamped.
Yeah, right.
It's stamped.
Okay. All right, so I guess I'll just ask if there's anybody from the butters that here to be given this petition for next. Let the record reflect that nobody has come forward on that. So, you know, just as a point of order, we are a five-person board with three alternates. So these types of petitions require 4 votes to carry. Okay. One of our members, Mr. Kuchar, is not here tonight. Oh, yeah, I forgot to note that's an excused absence for Mr. Kuchar in the record. So we'll have one of our alternates step in. Probably you'll have Alexandria on your petition, and we'll probably switch with each petition, a different alternate with each petition. So we'll just go that way to fill the seat. Okay.
Sure.
That's it. I don't have any. Looks pretty straightforward to me. So we'll close the public hearing.
Motion to close, Mr. Chair.
Okay. Is there a second?
I'll second that.
All in favor of closing?
Aye.
Aye. Okay, that's closed. Any further discussion, deliberation? Hearing none. I'll hear a motion to move the petition.
I will make a motion to approve the petition of Keith and Amy Harley for property address 360 Winter Street, North Andover, Massachusetts, 01845, map 104.8, parcel 0012, North Andover, Mass. 01845 in the R1 zoning district. The petitioner has requested and I move to approve a special permit from 4.121 and 4.121.17 of the zoning bylaw, family suite in the R1 zoning district, as required by the zoning board of appeals.
All right. Including the submitted plans, right?
Thank you, Mr. Chair. And if I could reference, don't sweat it, I'll get it. If I could, Mr. Chair, reference plans submitted with the application, specifically a plot plan of land for number 360 Winter Street, North Andover, Mass. 01845, prepared by Sullivan Engineering. Date is June 14th, 2016. And there's some additional plans attached there too that are not necessarily numbered. 1, 2, 3, 4 that are not numbered. And then we get into some elevations. There's a rear elevation dated dated June 5th, 1984, with revisions by Dan Batting and Malden. There's, it looks like it's marked plan number 6, then another one, plan number 5, 4, 2, and 1, Mr. Chair.
Plus our certification,
Yeah.
right?
Oh,
Square
good
footage.
gravy. Better reference that, baby. Petitioners also submitted a letter from Dan N. Batting, architect, mass registration number 6027, a letter dated May 25, 2016, certifying that the in-law apartment will provide 780 square feet of gross living area, and that represents approximately 24% of the approximate gross living area of 3,230 square feet.
Okay. We get it
I'm
all?
exhausted, Mr. Chair.
I know.
I second that.
Motion and a second. Any further discussion? No further discussion. We'll call the vote. Ms. Jacobs, you in favor of it?
Aye.
Aye.
Koch? Ellen?
Yes.
I'm also in favor, so the petition passes. We will issue a decision within 14 days, and then there's a 20-day appeal period. Okay?
Thank you.
Sure.
Thank you very much. Good luck.
All right, we'll try to get back into our regular order here. So the next on the agenda is the continued public hearings for the dimensional variances of Ryan Sharenda for the address at 54 Phillips Court, North Andover. And 320 Pleasant Street, right?
Yes.
Okay. Welcome. Attorney Vaughn, how are you?
Good.
Hi, how are you? Nice to see you.
Good. Thank you. As the board will recall at our last meeting, we opened the hearing. There was a lot of input from abutters. We left the meeting with kind of a task list from you guys of things that you'd like us to revisit. I submitted a memo addressing what I think were the 6 points that we left with last time. I've tried to answer a few of them. What we'd like to do tonight is maybe run through those points. A couple of the issues which really dealt with site design.
Looking for the memo, just give me a second. Oh, go ahead, I mean, you can keep talking.
Okay.
I'm sorry.
July 29th?
It was actually submitted for the prior meeting, but because we continued.
Because you, oh, with the
Is it the
August
one
meeting?
dated July 29th?
Exactly.
Okay.
Right. So a couple of them are design related, and what we would like to do is kind of discuss it a little bit, take a little bit more further input out of this, give abutters a chance to perhaps respond with some further input, and then continue the meeting, and then have some final architectural and survey plans addressing some of the more design points put in front of you at a next meeting for a final disposition.
Before you go on, I thought that's what you did last time, and I thought that's the reason why you requested to continue it till September. I thought that would have been done.
We never met.
I know, and that's why they requested to have the time off to address these issues.
So one of the items is we weren't able to meet with our neighbors due to conflicting schedules for a good long period of time, and we didn't want to approach our architect until we had that meeting with the neighbors. So we've had that meeting, discussed a lot of items, then went to our architect. Unfortunately, at that point, she was on vacation due to the summer, so she is now working on it, just wasn't able to get it done in time for this deadline. So there are some, I think...
Yeah, I think I had submitted with the...
Just to
Okay.
McIntyre's point, to the extent that you're requesting a continuance, you want to continue the time waiver, so there's, effectively, the board isn't under any pressure to act.
Exactly.
As long as you're waiving the time.
Exactly.
Okay.
Right.
All right, I'm just looking for your memo. Is the one dated July 29th?
Exactly.
Okay. Sure, okay, well,
So I think the first point we were asked to address was one of lot merger and why it was we were looking for a variance for both of the lots as opposed to just one of the lots. I quoted in my memo section of the zoning bylaw, which kind of addresses this, and I also included some MCLE materials, which are very dry and boring, which kind of just show you exactly how confusing this area of the law is.
so that's, so people that don't know, that's Massachusetts Continuing Legal Education.
Yes.
Okay.
Right. Which talks about zoning nonconformities and substandard lots.
What's the difference between MCLE and MGL? Mass General Law as a...
Yeah, MGL is Mass General Law. It's a statute. MCLE it's just a continuing legal education. So it's a legal treaty of sort, I guess, which kind of just outlines the area of the law, the MCLE. That's not it's not a statute or a zoning bylaw or something that's binding. It's something that's authored by attorneys that suggest this is kind of the guidance in this area of the law. But I think the controlling section in the statute is, excuse me, in the zoning bylaws, section 7.81, which I've quoted, residential lot areas and frontages above required listed in Table 2 shall not apply in any residence district to any lot of less area or less frontage than above required, meaning what's set forth in the table of dimensional requirements. And the underlined and highlighted part of if such lot not be adjoined by other land of the same owner, available for combination with or in use in connection with such lot. So that it's really that language right there which is controlling, because in this case the two lots have been combined effectively for zoning purposes. They've become a single lot. So when they're separated, both lots in fact would need to comply.
Can you give an example? It might help some folks to understand of what would have how would the lots have not have merged? For example, what would have made them not merge back in the day?
Back in the day would have been perhaps if a husband by himself owned one lot, and then the husband and his wife as joint tenants owned the lot next to it. It would have been a different legal title in each. If you had one property in a trust and the property next to it owned individually, so it's really effectively a mechanism of ownership if they're not owned in common ownership by what's the same legal entity or person. Okay. And that's really the significance of the language in that, owned by other land of the same owner. So, and just by effect of this provision, we don't comply with it because of the fact that it is in common ownership and has been, and we don't dispute that fact. Since, as of right now, both lots are owned by the same person. It's something that once done, you can't undo it. If Brian were to deed one lot out, it's kind of been infected at this point, I guess, is a potential word you could use, that zoning nonconformity will follow it.
I mean, you could effectively, am I mistaken to think that you could always deed out something in the context of an A&R plan, an approval not required plan, but that doesn't mean it's buildable, it just means it's a conveyance of property.
Exactly, you could convey it, but what you're doing by virtue of the conveyance now is making the remaining lot non-conforming to zoning, which is the very issue.
The lot with the structure.
Exactly.
Okay.
So I guess, I don't know if there's any further questions with respect to lot merger or why we were looking for two variances.
Anyone from the board has any questions for you?
Okay, so the second issue that
I'll open it up to the audience after we're done with their presentation.
Thank you.
Sure.
Okay. So the second issue you had asked about was the 2002 variance application, where this matter had previously been in front of the zoning board. I've included the decision from 2002 with the materials that are submitted if you haven't seen it already. It was at that time it was a 2-2 vote, so that the variance request did not carry. I also included what was a memo of, I guess, opposition at the time, outlining what some of the neighbors were unhappy with. I'd note that the abutters at that time were upset that an applicant was purely looking to derive profit from this transaction, and I think in this case it's a little bit different because we're not just looking to maximize profit and move on. As was discussed before, Ryan's looking to stay in the neighborhood, be part of the neighborhood. Is just looking for a place for his expanding family, and he would prefer to do it here.
It's a different applicant, right?
Correct.
Yes.
Different applicant.
Different owner?
Yes.
Yep.
That's 3 owners ago.
3 owners ago.
Just for the record, I was on that.
And which way did you vote?
I denied it.
Can you be impartial now?
I always have been.
Okay. Yeah, I think you're the only one that was there, right?
Mm-hmm.
Okay.
So,
We can go on to the next one.
nothing to be seen there. So, the third issue that was raised was there was some question as to a possible provision in the zoning bylaw that dealt with 10,000 square foot lots and whether in fact a variance was needed or whether a special permit was possible. As best as I could tell from my review of the bylaw, there wasn't anything else that would apply here. I think we do in fact need the variances. There was, however, applicable to the R4 zoning district, section 7.82 of the bylaw, had something which was perhaps, I forget who raised this issue, but
My father, actually.
was it your father? Okay, may have been thinking about, which was in R4 districts only, 2 or more vacant lots mutually adjoining may, with a special permit from the Board of Appeals, be permitted to be combined into a new lot or lots of not less than 10,000 square feet area each, and with not less than 100 feet street frontage, provided be shown to the Board of Appeals that each such lot was lawfully laid out and duly recorded by plan or deed prior to January 9th, 1957, and the building inspector shall permit the construction of one single-family dwelling on each such 10,000 square foot lot. I would say, although I think, as a technical matter, this probably doesn't apply in this situation because we have 2 lots and we have less than 20,000 square feet where we can't come up with lots of 10,000 square foot each or 100 feet of frontage each based on just the area we're dealing with. What is interesting is that the corner lot by itself would, in fact, comply dimensionally with this provision. The corner lot itself is more than 10,000 square feet and does have 100 feet of frontage. However, because of the lot merger issue, by now effectively separating that from the remaining parcel would then be non-conforming and still would require a variance. And that lot, standing on its own, wouldn't really be.
You mean the remaining lot with the structure would be non-conforming?
Correct. So
you would.
So
in theory, what this is saying is you could file an A&R plan. You could do an A&R, but shows that 10,000 square feet, have one conforming new lot, and then have another existing structure that's not, the old lot is not conforming? Is that what I'm hearing you say?
I'm saying I think
that's your opinion?
Well, yeah, my opinion is that we couldn't do this because the old lot is left non-conforming, not of 10,000 square feet.
Well, you could do it, it's just you'd have a non-conforming, you'd be left with a non-conforming lot. Did you file an application for special permit?
No.
Okay, so you did, so this is a discussion point.
This is a discussion point where I don't, exactly, and I don't, yeah, I mean, I suppose it could be someone's opinion that rather than have 2 variances, we could perhaps seek variance on the non-conforming remaining lot and then a special permit rather than a variance on this lot. That would be a separate and additional filing.
Yeah, it's just something, it's something that came up, you haven't filed it, and you're just answering the question.
Exactly.
Okay. Did you have any discussions with the building inspector around this or not?
No, I did not.
Okay. Inspector of buildings, I don't know, I get that. I'm always, I keep getting corrected on this job,
Yes.
I can't get it right. So whatever the appropriate title is.
So in any event, again, on that point, I think it was really close to being a useful bylaw provision, but because we still have the existing structure as a non-conforming lot and still need to deal with the variance on that lot, I don't think that this helps us, but I was just responding as to, the question that was raised at the last hearing, and
Well, it's interesting and discussion points, I think, for the board and the audience in that, the special permit standard is a less stringent standard than the variance standard, but it does carry with it the characteristics and conformity of the neighborhood. So, that's something that it shifts from soil shape and topography to what we want to do there fits there. So I don't know, it's a different way to approach it. Probably gets the same level of scrutiny one way or the other, but it's an interesting point.
I don't know if anyone else had any further questions about that bylaw provision, or no?
Any comments from the board? No, it's not before us. It's just,
Right. Okay, so then I guess kind of shifting now onto the more substantive issues. Ryan did have a meeting with some of his neighbors, not all of them. I believe he tried to meet with the neighbors that were the closest, and he did take into account the comments at the last meeting and the board's comments. He's submitted a very preliminary kind of concept plan, which is, I think, the direction he.
That's the wrong one.
this one?
I'm just comparing the two.
Okay.
Oh.
So you have a revised concept for what you'd like to
Correct.
construct?
Yeah.
Which is,
Which
and you
is-
shared this with your neighbors that you met
Yes.
with?
Yes.
That you met with?
Yes. They've seen that one. Yeah.
But it's on file at the Board of Appeals, because it's in our package.
Right.
Okay.
So, his plan following this meeting is to have new architecturals prepared, have a new survey prepared, to submit those and to have a more specific and formal final plan in front of the board to act on for disposition one way or another at the upcoming meeting. I would just note that he tried to really scale it down to something which was smaller, tried to go with a design which he found to be more consistent with what's currently in the neighborhood. And I don't know if you had anything to add in terms of your...
No, that's pretty much. I mean, we proposed the wrong one last time. Too big a house for the neighborhood, doesn't fit in. And this, it's pretty much all capes. And I mean, they're duplex capes, gambrels in the back. So we tried to have whatever the front is look like the rest. And
How does this, I mean, I definitely, I certainly, I can offer this comment. I think it's a nicer looking structure than a design than what you're proposing the first time. Because I do drive often in that neighborhood and around, up and down, and I've been past your lot and up and down the streets and looking at the surrounding properties a couple of times. So I guess my question would be, with this design, as nice as it, or as appealing as it is, say, to me, on paper, how does it fit within your lot layout and your landscaping? Like, how does it fit? And, in terms of not only the size, but the orientation with the other surrounding structures.
so one of the things that, and I'm sure my neighbor's going to mention this, that we discussed when we met was which way the house would face. And we had discussion of it facing Pleasant Street, but in the end, the consensus was that they don't want to look at a garage, because the garage would have to be on the side of the house. So it would face Pleasant Street, the front door would face front door would face Phillips Court. And we would try.
What we're looking at in terms of your concept would face Phillips Court?
Correct.
Yes, and we would try and push it up the hill as close to Pleasant Street as possible without taking out any trees. I mean, we'd probably have to take out a couple, but try and limit it as much as we can to enable space between the two houses. One of the items that was brought up was when Mr. Hamlet goes out his front door, he looks at a green space right now, and the goal is to push it up the hill so that he's still looking at a green space. It would be between the houses, but
Yeah, I understand his point. My question is, how does that look in terms of the overall concept of the layout, you know? I mean, obviously, this was a lot that was laid out originally and not constructed.
Correct.
So everything that's sort of laid out on that road, you know, fits, you know, so is what Mr. Hamlet's looking for. Does it still fit in the context of that overall layout? In terms of its orientation and where you're setting it,
Right, and again, you know,
or you propose to set it?
our hope, goal, plan, intent is to have it sit on the lot and to be consistent with the rest of the neighborhood. That's, you know, before the next meeting, that's what we task the engineer with doing, to address kind of the how it's going to sit on the lot, where the foundation's going to be, what we're going to do for the drainage issues was one other issue that was addressed, and the landscape
'Cause I'm sure that's
issues.
something that the abutters would be very interested in, not only the concept, but,
Right.
you know, back to kind of square one is, how does it look?
Yeah, so one
It
of the-
maybe not, maybe the testimony, you know, maybe the positions are the same from the last meeting, some said they don't want to see anything. You know, I don't know, I can't speak for them, but
One of the other things too we did with the engineer was he averaged out the houses, how far away they are from the street, and it would line up with that as well.
so is that sort of how you came up with this square footage? Were you trying to match what was there?
The square footage is in line. I mean, across the street's 2,800. My house, which would be next door, is a little over 2,300. So, and then, I mean, it varies throughout the whole neighborhood.
So this
But it's
pro-
generally 2,000s, 2,300.
This, well, what you submitted to us says 2,400.
Yep, so that would be what it would be.
When he said he means his existing
Yeah, his
house next
existing
door,
house,
correct,
yeah, sure.
was 23.
Okay.
And just for discussion purposes, and so everybody can hear it out loud, the reduction in a gross living area is, you know, what's the magnitude of that from the one proposed back in June?
So the one before had 3,000 on it, but that was including that porch off the back. So it's down 600. So to be more in line again across the street's 2,800. I'm a little over 2,300, and it varies throughout the whole neighborhood. And meaning my existing houses.
Understood.
Yeah.
Is the height in line too with the roof lines that are there?
We're gonna try and keep it in line. I don't have the height yet, so
I realize they build them differently, but I just,
yeah, I'm gonna try and keep it as, you know, in line. I mean, right now my house is 7-foot ceilings. It's an older house, so it might be a little bit taller, but you know, due to its current construction, you know, 2x10s versus 2x6s, I think I have in the basement.
Your home's a single family?
No, it's a duplex.
Yeah, duplex.
Yep.
Just because sometimes I get hung up a little bit on arithmetic, and I want to be clear so that I'm not misleading myself over here. And I absolutely appreciate that this is merely a concept, you know, provide for illustration purposes. But what we are collectively talking about with this new concept is roughly a 2,400 square foot house with a footprint that's approximately 44 by 44.
Correct.
And, you know, quick math of the 44 by 44 is 1936 per floor, 3,800 square feet. So we are losing the 1,200 square feet in order to get down to the gross living area, down from 38 to 24-ish. Well, where is that?
There's a cathedral ceiling in the front right part of the house, which is a living room, dining room area, so you lose 2 rooms above there. And the second floor is, you know, it's a slant there, so you're not
It's a
getting
cape
the full.
style, right?
Yeah, it's a cape, so, which is in line with everything else. So, and again, the garage is 23, I don't know, it's 23 by 22 maybe or something. So that takes up good space.
Thanks.
Yep.
any other discussion points on the design?
For the record, I'm not in agreement with the change of design. I think I prefer the first. I'm of the belief that neighborhoods don't have to be homogenous, and that we all are better people when we have diversity in our lives, be it in the color of our skin or the context of our neighborhood. So that's my personal opinion. I'd love to hear from the neighbors.
I think you have a couple of points that you want to address before.
Yeah, I was going to go to the neighbors as soon as you were done with the memo.
Yeah. No, and the last couple of points, we've kind of wrapped them in. It's just the issues that you had raised were, that we haven't addressed here, are design. This is just conceptual. We need to come back with a specific design, and it needs to address, exact dimensions. It also needs to address where exactly it's going to lie out on the lot, and I think the two specific issues that were raised last time that you wanted to see addressed were drainage and landscaping, and we intend to address both of those with the final design next week. I mean, as a general overview, Ryan kind of told you what he's going to task the engineer and architect with doing, which is trying to make it as consistent with the current neighborhood in terms of where it lies on the lot, while keeping as many trees as we can, but pushing it back as far as we can. So, again, more work to be done. Specifics will be in front of you for the next meeting. We just, Ryan didn't, it's obviously very expensive to engage attorneys, engineers, architects.
Thanks, Ryan.
No problem. So Ryan wanted to try to get as much input from everyone as he could. He could, only meet with so many of his neighbors, but he wants to hear from you, from them, and go back to his consultants and come up with what he thinks is the best plan that he can put forward for everyone for making a final decision.
Okay.
I actually have a comment. I just want to say thank you, Attorney Vaughn, for addressing the issues in a memo form, which I really appreciate. I mean, you addressed all the issues, which a lot of applicants do not do. Actually, lawyers of applicants do not do, and each one has been written down, and you addressed all of them. Thank you for that. I appreciate it.
It's very nice. Thank you. Well done. So why don't we, do you mind if we open it up to,
Absolutely.
about our comments, statutory abutters, I think would be most appropriate, those who are listed. If you want to comment, you can, and if they don't want to, I think there was a hand earlier. Sorry. Sure, come on up to the microphone, just name and address for the record.
I'm Diane Donovan. My husband and I own 2325 Phillips Court. And I have one question that I have a real concern about. That is that his attorney keeps saying that the lots were merged. I'd like to see a document, because I have done research myself, and I know the family, too, that owned the property. And the person that bought that property from that family foreclosed on the property. So I need to understand. I don't have a document. You can say whatever you want, but I need to have a document showing this, because nothing in the deeds that I've looked at from the Registry of Deeds shows this.
Well, if maybe I can.
I think the butters deserve
Yeah,
that.
I can shed some light on that a little bit for you, and then we'll have Mr. Vaughn respond to all the questions once all the questions are done, just to kind of keep it early. I think the merger doctrine that he's talking about, that doesn't necessarily mean a new plan is created. He's talking about zoning merger, which happens by operation of law. So, as he's making that pitch, explaining to you why he just couldn't go in and get his building permit, if the lot exists, but by operation of law, because you had two non-conforming lots after the zoning change, there's effectively a merger. And then the town, as my recollection, continues to tax it, I think, as a separate lot, because the lot exists, but it's not buildable by operation of law without some additional permitting. So I don't think there is a document per se. I think there is an analysis, both engineering and legal, that says these are the bylaws, this is what you have, and it was in common ownership, the same person owned it, and then therefore there is effectively a merger by operation of law. That's what I understand it being.
Okay. But in order to buy that property, the property was sold in a bankruptcy, for $275,000. Okay, that's what the deed states. Someone must have done a title search. I understand that when it comes to bankruptcy, it's whoever handles the bankruptcy process. Okay,
Yeah.
but there's got to be a paper trail somewhere.
But what is it you're looking for, that the
Well,
lot
I'm
is
looking-
there or not there?
Because I don't believe that I personally do not believe that that lot, if that lot was really to be buildable, why is it that the zoning board denied, Coates family to be able to sell it?
I can't speak to what happened in 2002. What I can tell you is that lot is part of a layout, of a planned layout when all the other lots were constructed. It's not uncommon that people would hold 2 lots or buy an additional lot at some point, or however it came to be in common ownership, and then just didn't build on it, and then the zoning changed. At some point in time, the zoning changed, which then rendered the lot to be unbuildable. It happens very often in all cities and towns throughout the years, and that's what creates, quite candidly, tomes of these books called Massachusetts Land Use Planning that everybody has to refer to in terms of trying to decide what, if anything, they can do with their property. It's not an uncommon analysis that has taken place, and it may be no one ever did a new survey to show one lot, because I don't think there's any requirement to do it.
They had their lot surveyed. I saw the surveyor.
To create, there's all kinds of law as it relates in planning law. So I think that, I'm not going to, I'll let Mr. Vaughn give his final answer when he's ready, but I think, as one member of this board, I understand why they're here, because we see it often, in the context of the years that I've been here. And so I think the approach that they're taking is the only approach that they can. I own this lot. It used to be an existing lot. At one point, some other applicant wanted to do something. I don't know if it was the same. I don't know if it was different. Nobody knows. But it was denied. Ms. McIntyre was there. But what's relevant is what's here today for us, I think.
Yeah.
For the record, I can't remember back then, so I don't remember why or how.
It's not the same applicant. It's not the same parties. It's the same land.
And I would just reiterate, I think, Al, you said it perfectly. I mean, I think if you're looking for a document which shows that this merged, you're not going to find a document or a plan which is what you're looking for, because it doesn't exist. It is deemed to have merged as a matter of zoning law by operation of law because of the fact that it was held in common ownership. And I think the other issue that I would say is that
it doesn't mean it's not taxable.
Right.
Well, I know it's taxable because the revenue...
So the revenue keeps coming in, you just can't do anything with
Right,
it.
I understand that.
And
My taxes keep going up,
sure.
too, so...
I mean, they don't hesitate to tax you, early and often.
All right. And I mean, and I guess the only other point I would make is, oddly enough, it's not as though I'm here arguing that the lots didn't merge. I'm admitting, in fact, that the lots did merge, and that's why we're even here seeking the zoning relief that we're seeking. That's why we're seeking the variance. The lot is not buildable from a zoning perspective right now without the variance, and that's why we're requesting the very variance. There is no plan which exists which shows it without the line, because the only plan that was ever recorded at the Registry of Deeds that I know of was the original plan. So I mean, I think that it makes perfect sense to those of us that probably have done it a lot. And I guess
that's why I had asked earlier for some layman explanation to the audience in terms of this sort of stuff. But I don't think you're going to find a plan, ma'am, that says that. But I think as it speaks to the merits of what's proposed or not proposed, I think that's what's most relevant for this board to consider, not the law that brought him here, but more the merits of the proposal.
All right. And I would just add, I mean, the fact that it's very confusing should not surprise anyone in this room. Even, in fact, the MCLE submission, one of the very first paragraphs of it says, this subject remains a continuing source of confusion for zoning lawyers, building inspectors, and town council. So these are all real estate professionals who, the professionals say it remains a very confusing source of law, area of law for all of us, and it absolutely is.
I heard from Attorney Vaughn's argument tonight, or his redress, that it sounded to me, and I don't want to put words in your mouth, but what I heard was, if you wanted to file a special permit to seek to create the lot, make it a valid lot another way, there is still another way with which you can do that in the bylaw. So, and I don't know what the merits of that would be, but it sounds like there's so many different ways for them to try to achieve what they're doing. This is the path that they chose, right?
I would say that's a fair assessment.
And I may say also that, this is not considered, obviously, in hardship situation, that they have to build this house, okay? We've gone from 3,000 square feet to, first it was 3,000, maybe 2,800, now we're doing 2,400. We're looking at the designs and stuff. And they're sitting on a nice piece of property anyway, and they got it for a steal, okay, as an investment. I just feel that if they really wanted to build something like this, they would have built something elsewhere, not on that lot, not in that R4 district.
Okay,
That's the way I feel.
okay. So you're for or against what they're proposing?
Against.
Okay, thank you.
I have a question.
Sure.
On this map, the lots that are 8 and 18, do you happen to know if those are single family, two family?
I'm sorry.
On this one.
What points are the ones that you're?
The one that's labeled lot 8 and 18.
I've got it.
Can I come up to yours?
Yep.
That is a duplex.
That's a big lot.
And that one is a duplex, I think. Can you guys,
So you're looking at the layout?
Yeah, well, because
Yeah.
those are the two that are actually under the square footage of what his lot is. They're both duplexes?
Yep.
Okay. Those, I bring this up only because 8 and 18 are both under the 7,500 that his existing lot is, if the lots were to be split. So my question came to is how that's going to look, kind of, so to speak. And if those lots are smaller and it's a duplex, that's kind of something for me.
Okay, yeah. There's other about it, yeah, please. Welcome. Hi.
My name's Ellen Carter, and I'm a resident of 40 Phillips Court. So first, I just want to say that, Mr. Schwender is a wonderful neighbor. He's a great person. I certainly don't speak here lightly. As I mentioned at the last meeting, I had some serious reservations, and you did ask me, if he dialed down the plans, if I would have changed my opinion, and I kind of reiterate my other neighbor that I have not changed my opinion on the matter. And again, that's with all due respect to Mr. Schwender.
Sure.
Like I said, we live in a wonderful neighborhood, and I certainly recognize that speaking out on an issue could cause, a little bit of upsetness in the neighborhood. So, like I said, I do not take this lightly. I just wanted to kind of put that out there. But
They're hard, we know they're hard.
Yeah, it is
Positions
tough.
and
It's
hard-
a horrible. Like I really feel like
We're
it's a
always
really
looking
tough
for emergency
situation.
exits.
You understand kind of where I'm coming
Totally
from.
get it.
So I don't want to kind of bore you. Like I already talked about a lot of the issues last meeting that I had, a lot of the reservations that I had. I guess my questions tonight really focus more on the basis for the variance. So I know Mr. Vaughn wrote a lot about that he was qualifying on the topography for the variance, and obviously I'm not a lawyer, and a lot of this is far beyond my comprehension. But from what I kind of
I doubt
understood,
it. You could get it, I'm sure.
it seems that he needed to qualify, or Mr. Sherman needed to qualify based on either a shape issue, a topography issue, or a soil issue, and that had to be related to a hardship that had to be owing to one of those three things, and then also be for the public good, not
An
detrimental.
excess. There has to be so the legal standard for variance is soil shape, topography, it's a nexus within the lot itself, right?
So I guess my question is that his vacant lot is 10,500 square feet, and I'm confused as to why there is any topography issue. There is a slight slope coming off of Pleasant Street. I would argue that it's not unique to his property. We're kind of built on the other side of Kittredge Hill, so my property has a slope, several of the neighbors have a slope. So I just question, I mean, first I kind of even wonder if the slope is on his lot line and exactly like how that slope provides the basis for a variance.
Okay, well, that's a big answer that he's going to have to respond to, so.
And like, I just also kind of wanted to know, like, you can't qualify as far as, like, I'm asking you really, or the experts, is like, can you qualify for a variance just because your lot is too small?
Well, every application for variance, we look at on their own merits, so the board itself, has discretion in terms of how they apply the law based on the facts that come in to evidence, at these meetings, and the soil shape and topography issue is the legal standard, and I can't remember if you hit on it in the first meeting with your first memo or not.
We did discuss it, and there is a steep slope on the very far edge of the lot, which I would argue is not consistent with the general, more gradual slopes in the rest of the lot or neighborhood. I would also note, we do, of course, address every variance application on its own merits. It's always one where, we can say, we all know that there have been a number of variances granted in this town for undersized lots, and they're granted in every town and city throughout this the Commonwealth. It's on its face, if to say that there you can't grant a variance purely on the basis of square footage and not being able to acquire it based on a pre-existing dimensional requirement of lots in a neighborhood would mean that probably every variance that was ever granted for an undersized lot was invalid on its face. We do know that the board does have some substantial discretion in decisions that it makes. We submitted an argument as to the topography, and we'll stand on it.
Yeah, I think, these things sort of get fleshed out a lot through the hearings, and, I can't speak for you. I can tell you that I think generally, this board tends to look at the totality of the issues as it relates to soil shape and topography, and, they vote if there's enough, for lack of a better word, evidence that came in, to meet their finding, to meet their threshold. An example like this is at some point in time, they had a buildable lot when it was laid out on this, right? At some point in time, October 1953.
Right.
This was deemed a buildable lot.
Right.
Right? Then somebody bought it. And then the zoning changed. And then you can't build on it anymore.
Right.
And then the whole theory of variance law is like, geez, is that fair? I have a lot, it was buildable when I bought it, and I can't build on it anymore. That's sort of what sets the tone, I think, in terms of, an application like this as it relates to soil shape and topography. It doesn't mean they're going to meet the threshold. It doesn't mean the board's going to grant it to them. It's just, that's sort of the argument that comes in addition to the literal need for the variance. But, I think those are things that all get factored in.
Is everything else built on this in here? Is there houses on all these? So
Yes.
you have something that...
But we know that lot's not a lot anymore,
Is
right?
that
By operational
the
law.
only lot
Right.
that's available to be built? Because
Exactly.
on the other side, there's two adjacent lots that are very similar, that mirror these two. So those are already built on?
There's no other
It's
open
22
lot.
and 23? Those are built
I
on.
believe so.
Yeah, everything around there's built on.
What's interesting about this lot number 12 is if this was simply owned individually and not in common ownership with lot 11, if somebody just held it and never built on it, it would effectively be what's known as a grandfathered lot,
Correct.
right? And it would be protected and it could be built
It
upon.
would be by right buildable.
by right.
It would still
But because it's owned in common ownership, because this keeps coming up, so this is sort of, because they're owned in common ownership by the same person, when that zoning changes after so much time or whatever, that line just is supposed to magically disappear, even though it's still there. That's why it gets so confusing, Does that create some sort of a hardship as it relates to soil shape and topography? I don't know.
Oh, and I would.
I don't know.
I mean, I would also, I guess mention, that you discussed earlier, other alternatives and whether a special permit were possible, and if we imagine, because everyone is looking at these as two separate lots, and if we imagine as though this line doesn't exist and 11 and 12 are one big lot, that gives you a pretty big building envelope, and by right we can have 2 units, and who's to say that we can't just say, all right, well, this 2-family, we're just going to turn it into a 1-family, and we're going to throw up the structure that Doug likes, and we have now essentially a 2-family property that complies with zoning. So, I mean, there are other alternatives. This is, everyone talks about our green space or saving, our lot, and the thing that's different is this lot is Ryan's lot. It's not our lot, and we're trying to come up with some type of a solution which can work for everyone. But Ryan could put a garage there. He could put a barn or outbuilding, I suppose. I mean, there's other things that can still potentially be done. We think that what's perhaps best for the neighborhood is taking into account everyone's comments as to, well, what would be the type of home that would have perhaps had it been built in 1957, but to today's modern standard, and will make it look like part of the same community. And we think that might be what's best suited for the lot, and that's what we're trying to do.
Could Ryan sell this lot?
No, Ryan has every intention of...
But he could sell this lot, and then this could come before the board, like you said, and that would be...
I mean, it sounds like it could. I mean, right now, it's one big lot being taxed as 2.
Yeah, I mean, it comes back to that same issue of lot merger. Could he sell it? Yes. Whoever buys it, do they then potentially have a zoning issue, or are they back in front of the board? Yes. And they're going to have to deal with the same issues because of the fact that it was after 1957 put into common ownership. That issue doesn't go away if the lot is sold to someone else.
But to answer Ms. Carter's question, though, to the extent that you were modifying your initial proposal, and you will definitely need to, touch on your soil shape and topography arguments, whatever they may be, to the board's satisfaction, I guess.
Yep.
Right?
Yeah, I also have a couple more things. I guess my other concern is that you're essentially, I respect you have 18,000 square feet, and that is a conforming lot right now by the bylaws. So essentially, we're now going to split it in 2 and have 2 non-conforming properties, which I just think, with a congested town, I know myself, this is a very congested street. It's like, why can't anybody just say, like, oh, I have this, like, I'm going to split this lot and I want to build on it too. Like, I think it could potentially set, like, a dangerous precedent, like, where we're taking a conforming existing lot and cutting it down into 2 non-conforming lots on a street that is extremely congested. And I also would just like to note, I think this did come up last time, it is taxed separately. And the vacant lot is taxed as a unbuildable lot, and it's assessed at $1,000. So he pays about $14 a year in taxes for a lot that could potentially be buildable in the town of North Andover, which I think we'd all be hard pressed to find a piece of property in town to build on for $1,000. And I just want to make that point, kind of like that. I know our previous neighbors had tried this as well. Obviously, it was a completely different time, different board, but I just think, to me, this boils down to like some of the principles of it and some of the legalities surrounding whether or not this really meets the standards for a variance.
I understand.
Okay. Mr. Chair, if I may, what I probably ask you is that according to the plan that we're looking at, 1953, we're discussing the merits of that plan. It was buildable back then, it's not buildable today. And then you're making the argument that splitting a conforming lot into two non-conforming lots. There's something extraordinarily counterintuitive about that. And I don't disagree with that sentiment. Not necessarily certain that I'm persuaded by it, but I understand it, and I'm sympathetic to it. But if I do a quick count at this 1953 plan, 19 of the 23 lots are currently non-conforming.
Yeah.
So the entire neighborhood is non-conforming. So we're really not, if this application were to go through and be approved, we're not changing much.
I agree, but it's extremely congested. We're on top of each other as it is. Adding another house, adding 2+ more cars to a street that we can already not fit 2 cars down at the same time, never mind when it's the winter. I think that these houses were built in the 1900s, well before we thought about having cars and all these other things. I also, some part of me wonders, these were mill houses built to serve the employees of Stevens Mill. And they built on every single square foot they could, but they left that open. And that to me has always been kind of a questionable.
Well, then you're making the argument, not to interrupt you,
Yeah.
on the other lots that are now built on.
Well, there's really no other lots that aren't built on.
Well, 22, 23, 21, 20.
Well, that's-
There's houses everywhere. Yeah, that is the only open space on all of Phillips Court.
Phillips Court.
They've always been there, those
They've always been there.
They're built at the same time.
Not from what this map is showing, there weren't, unless I'm reading
Right.
it
On
wrong.
October 5th, 1953, these lots were not built
Not
on.
built on.
Today they are built upon.
Well,
That's
I get
what we're
that.
being told.
I get that. That part I get.
Well, they were laid out, those were laid out lots, they just weren't constructed on then, but I understand the point, though.
Thank you.
I get it. I get it.
This is not necessarily a question for you, it's for Mr. Chair, perhaps the applicant. When did the zoning change that created the merger? Do we know? Do we have that?
1979.
72, I think.
72?
He's in the 70s.
You were
I
there.
don't think I've seen it all.
I was there. Was it the middle school or the high school at the time?
You guys are twinkles.
Yes, thank you. So, Mr. Vaughn will,
Don't work on it.
in your next memo to the board, one of the things you'll be doing is addressing those issues, right?
Readdress? Yes.
Yeah. Who else would like to?
I'd like to just ask a couple of questions.
Yes, sir.
Hi, I'm Ron Hale. I'm the direct butter of Brian. I'm sorry, Brian, I'm a little nervous. I'm trying to speak.
You don't want to see the garage?
Well,
What was your name, sir? I'm sorry.
I'm sorry, it's Ronald Hamlet.
Thank you.
I'm the director of his cross-street neighbor. I basically had a couple of things I wanted to ask, and as you kept talking, I come up with different thoughts, so it was kind of hard to keep track of them. But one of the things I really want to ask is, can you continually keep fighting a variance? In other words, it was already, the lot was considered not buildable back in 2002. So now you're saying within a certain period of time, someone can come and reapply for this variance again, even though the land has not changed? I don't
Yes.
understand how
So
that
after-
works.
So my understanding of it is, generally speaking, because I'm not giving you any advice, but generally speaking is there's 2 years, right?
Okay, I've
So-
never heard something about that.
So it can reapply after 2 years unless there's a special permit by the planning board or an action by the planning board allowing for a repetitive petition within those 2 years.
Okay. All right. Then there was another issue you happened to bring up a few minutes ago that was about grandfather clause. And you were saying, well, these people, they would have been able to use a grandfather clause to build a lot.
Right.
Well, Ruth owned that house for 50 years. Wouldn't she have been grandfathered to sell that lot? Or do what she needed to do to produce it? Because basically all it was for, I was against it then,
Yeah.
but the woman, like anybody who's working, knows what seniority means. I mean, 50 years is 50 years. If you're going to give someone a break, she's the one who should be getting it.
I think, I apologize if I was saying anything confusing. The example I was trying to
Well, I
make
mean, you spoke about the
was
grandfather clause.
if the lot was individually held with no other lot, my understanding is that would have been a grandfathered lot, but because it was owned in common ownership with the lot that holds the house, that's when the merger of law took place, that's part of Mr. Vaughn's argument for Mr. Sharon.
Well, I guess the other question to me again is, when she purchased the property, her and her husband,
Yeah.
that was considered a buildable lot at that time,
I don't know
right?
what it was considered then.
Oh,
Because I don't
okay.
know when they purchased it, I don't know what
I
the
thought he
zoning
was
was
saying that
then.
it had changed in
What a-
certain years.
At some point in
Right.
time,
I mean, it's-
the lots were buildable, because they were approved, and at some point in time, I don't know when, the zoning changed, and there's merger that takes place. That's the history, that's the general history of what creates these types of applications.
No, I understand that.
come
That's why
before us.
I'm actually, I'm a little concerned as to why we're actually even here, because the property has been denied to be built upon, and I know, there are certain things that change in time and stuff.
I can tell you why you're here, because Mass General Law, Chapter 40A allows it. Okay? There's a state statute that controls land use and zoning that says that they can be here. That's why we're all here.
Well, no, I know. I guess what was driving my thought is that it was denied. I just can't get past it, that, if somebody comes
Yeah.
through with,
I get
no offense, with a suit, and this property is gonna get built. I mean, that's,
I don't know what's going to happen with this
well, I
petition.
mean, I just say, I guess we can move on. It's just that I was concerned that the variance, once attached to that property, which, I mean, I asked Brian about that, and, when he purchased the property. And, I mean, I would think that would have been something that he would have been, looking at when he purchased it.
I'm not going to answer the question any more than I did for Mr.
Okay,
Vaughn, but
well,
I
I'm
believe
just-
it's 2 years.
Right, so basically, anybody can reapply on anything that's been denied by you guys in a 2-year period.
Yeah,
All right, that's,
unless the planning board says they can come back sooner. I mean,
bring it for
we
lunch.
didn't make this up, It's not our rule,
But, okay, I just wanted to speak to one thing that you spoke about, diversity. I don't know if you were around when they built these houses right down here on Mass Ave in Osgood. There was a big fight about those houses conforming to the neighborhood. So it is an important thing that happens. I don't know if you were there when they were doing that, but those houses were argued seriously by the people on the common. That house.
You're
those
talking
houses.
about the two new ones
Right
on the
there
corner.
yeah. They've been about 10 years now, I think, right?
Maybe more money.
The ones on the corner.
Which one are we
Right
talking
up here, on Mass Ave and,
One, the two that in the old center district,
Oh,
you got
two-
the foundations there.
yeah.
Oh, okay.
Yeah.
I was in charge of that one.
Oh, yeah. I opened up a can of worms on that one.
Okay. My name's George Sharenda.
I
I'm
know.
chairman of the Old Center Historical District Commission. Okay, on those lots, they had to go through the Old Center Historical District
Okay.
and get our approval.
All right.
The gentleman started the houses without the approval.
Oh.
The building inspector was supposed to say you couldn't do it. They put the foundations in. The building inspector went to him and he ended up taking them out.
I didn't know that. I just remember I remember there was an argument about
Right.
the town was having an issue with that. That's all. I just wanted to just say that. I mean, to me, it's important. I mean, and I think most of my neighbors would look at it in the same manner. I mean, I don't know. I mean, basically, I guess part of what we live in is kind of a historic type of thing. I mean, like I said, the past. Nobody, unless you have a certain love for an older home, you're not going to live in those houses. You got to have something that means something to you there. So that's all important. I was just trying to get on that. But that's pretty much. I mean, they spoke mostly about what I wanted to speak about. And I think one of the other things, and I guess it really doesn't matter, but this stinks because it's creating a rift between me and my neighbors, and it just stinks. That's all. Thank you.
Just to let you know, on the merits of the 2002 variance, each one is presented differently. And as I said before, I did sit on that, but 14 years ago, this was probably presented different. I mean,
Right.
again, I can't remember what it was. I'm lucky I remember what I had for lunch today. It's just what's presented, each application is presented different. This could come back in 2 years if this was denied, it would be presented different again. So.
No, I just understand the point of the variance.
This won't be here then, except Ellen.
If it was denied, that doesn't necessarily mean, if it was, it just, each application.
No, I
is
understand
different.
what you're saying. All right, thank you.
Yes, ma'am.
Can I just say something on my...
Yeah, then, sure.
Oh, sure. So I just wanted to...
Your name, please.
It's Mary Schurender. I'm Ryan's wife. I just wanted to mention that when I met Ryan on one of our first dates, he said, "Can you live in North Andover?" and I said, "You know what? I love this town. This is a really nice town, and you know, I love the area that we're in because I love walking, and there's sidewalks right by there, and you know, as you probably know, there's not a lot of places to build in North Andover. You can't just go out and find a lot and just build anywhere. So, you know, and I love being next to, right next to Wire Hill. I go up there all the time and just walk around. And, you know, I just really love the space, and I love the green space, and I love the trees, and I want them to be there still. And, you know, and I think that Ryan does an excellent job, and his cousin does landscaping, excellent job at landscaping. You know, they're out there all the time just making sure the grass is green and stuff, even during the drought here, you know. So, I mean, we do care a lot, and we want to make sure that our neighbors are happy, and that's all.
I have a drain easement that's on the property at 20
Can you
years
just come,
ago.
I don't mean to be, just come back.
And I found this website, and it's dated October 21st, 1953. So there's a problem on our Phillips Court. People have problems in the basement, they have water in the basement,
Okay.
but I just want to bring that to your attention. If you're talking about landscaping and drainage, which we discussed before,
Yes,
I
ma'am.
think that's what you need to consider. But there is a deed on 4 properties, lots, by J.P. Stevens Mill, and it's book number 1233, 427. This is it.
And whose easement, who holds the easement?
Easements are Blackstock's, which are, you know, Ellen's property that they bought, and Raymond Canty's house, Ruth Coates, husband and wife of Phillips Court, and also lots 7, 8, 9, 10, 11, and 12.
All right.
And I think we need to consider that.
Sure, Mr. Vaughn will take that under advisement, right?
Just to offer some quick commentary just on the makeup of the board. I've been on the board for something like 5 years, and there is no one more suited to approach the drainage easements and water matters than Mr. Chair. That is one of his pet issues, quite frankly. So that's something that will not escape his attention, I promise.
I didn't realize I got a new title here.
You got that from your father.
Do I? Yeah, well, I mean, we do take it seriously. I mean, you know, one of the things that's always, you know, troubled me over the years is if you don't try to address those sorts of things ahead of time, then what's the recourse to the neighbors after the fact if something were to be approved? I'm not trying to offer a suggestion one way or the other, but the drainage and the easements and the flow of water and all that stuff is very important because, you know, that's what drives your neighbors crazy.
Mm-hmm. We will address it in the next plan.
I don't know what the water table is over there, you know, if...
Well,
It's high.
We all get water. We all get water in our basements. I just spent a bunch of money doing mine, and that's again one of the items they brought up during our meeting. And definitely in the engineering, we're going to try and address it so that there is a area between us and Mill Pond that water could be directed to protect not only myself but the houses down the line.
I mean, I think, you know, I think Paul's right. I mean, those are things that really do have to be addressed if you know, if the board is so inclined to hear it, because once you know, if someone were to start moving earth around, you're changing the flow, you're making impervious area. I mean, you know, it changes everything.
Absolutely.
You know, in that context.
yeah,
So.
and I would point out with respect to that, I think Ryan himself is going to be most impacted by the drainage issues because looking at the old plan, he's Lot 12, well, he's also Lot 11, and anything that he does on Lot 12 is going to most significantly impact Lot 11, I would imagine.
I mean,
So,
I don't want to get ahead of myself and say that, you know, the board's inclined to approve what you're proposing, because I don't know.
Right.
But you know, if that's the way the board goes, the drainage and all that stuff has to be addressed.
Absolutely.
I think.
I will interpret
And I-
your comment as you're not inclined to say which way you're going to go, but you are inclined to say that,
I don't know. I mean, I don't
you
know.
are inclined probably to say that you wouldn't be
If this board, you know, if this board
satisfied with
grants
anything that
variance-
did not adequately address it to you know, even get over that first hurdle.
Yeah, I mean, I'm keeping a very
Yeah.
open mind about
Huh?
everything that I'm hearing.
Yeah, I mean, I've never seen the easement that was referenced. That's book 1223, page 427. I'll pull it and I'll look at it, but I thought I heard her mention something about lots 22 or 23. That particular easement, if that's the case, I notice.
But these petitions, you know, they need 4 votes
Yep,
for approval.
right. This
You
is,
know, so
Well,
we
we're-
always, our practice is to move every petition in the affirmative.
mm,
But if you don't get 4 votes, it fails.
Yep.
You know, and then you're in that 2-year cycle unless you go to the planning board that we just talked about.
mhm.
Can you show me what's on 22 and 23, the size of the houses? Is that on the other side?
These two.
No,
Those are small capes. So that's the Fawns in town. There's 2 small capes, single families. And just as a point of reference to number 13, which is across the street on the corner of Phillips and Pleasant, is a single family as well.
And yours on lot 11? That's a
Two family, yeah.
I think most on Pleasant Street are single families.
Everything on the other side of the street is a single family. Even, what's that, 15?
That's 19.
19? 19, I think they actually just advertised it as a 2-family, but I think it's a small, like it's a big single-family house with a small apartment attached to it.
So it might not be illegal?
In-law.
Oh, why are you bringing that up? Is it not illegal, two-family?
No, I mean, they advertised it. They just sold it.
Oh,
They
because
just
real
bought it.
estate advertise it means it is.
No.
It's not true, you know that.
I know, but I'm just saying what they advertised it
Like,
as.
you cannot advertise a
And then-
family suite.
Sorry. And then 20 and 21 are both single families, which are that have frontage on Pleasant and Phillips Court.
All right, well, so we're getting close to 9, right? Is there anybody else in the audience that wants to be heard tonight on the new stuff tonight? Any other new points that the board wants to address? You know, anything they've heard. So what you're looking to do is to continue to the next meeting date. You're willing to sign the time waiver, so the board is under no pressure to act.
Exactly.
All right. And then, what
Mr.
else
Chair,
is there?
if I may, there's another thing that I'd love the applicant perhaps to prepare for next time. If there's a great answer today, I'm more than happy to hear it. But it kind of harkens back to something that Mr. Hamlet was referencing, which was, this merger thing is something that he would have expected the applicant, the buyer, to be looking at the time of acquisition. And that's kind of why Mr. Hamlet, that's why I was asking when the zoning changed back in 1972 and the acquisition is in 2011. So when we talk about years, it's about 40 years since the lot, merged, I guess, by operation of law. And so kind of being sympathetic to that argument, having it been cogitating on it myself, I'd probably ask the applicant, again, not to put you on the spot now, but I'd rather not submarine you and the next time you come, which is that, talk to me a little bit about, what are the applicant's obligations or what should or shouldn't he have done in like a due diligence effort during acquisition in 2011, which is not to suggest that it precludes the applicant. It's just something that I'd love to kind of talk about a little bit.
Right. Yeah, and, it would definitely be in existing legal condition that existed at the time. We're not making the argument that Ryan, thought that this was separately buildable. We're acknowledging that he bought it in this legal condition, and I'm not sure exactly of the circumstances, but I would venture a guess that it wasn't until Ryan happened to be married and looking to expand and then realizes, well, there is this lot, and maybe maybe I can get it approved. But that's not to put words in Ryan's mouth. That's just my suspicion.
Understood. So at the time of acquisition, this is not a plan that was concepted in 2011. It was only subsequent to those, a couple of years passed, and you say, well, gee whiz, life has changed a little bit.
Right. Life has changed a little bit, and I really like my neighborhood, and I'd like to stay here, but my current home isn't what my current wife or future family will be comfortable in.
My second wife might love it there.
First and only.
We've only been married a year yesterday.
I just have one question.
Yes, ma'am.
My name's Erin Morton. I bought my grandfather's house. My grandfather was Ray Canty.
Yes.
So I live on Post Court. And I guess my question is just, I don't know if this is something I can address to Ryan to look into, or if it's just addressing to the board, but.
Well, address to the board.
Okay,
We can
so,
ask.
just for the next meeting, maybe just information-wise, where we do live in mill homes, and it is, probably something that could qualify as a historical area, our street it needs a lot of work. It's something that could be overhauled and down the line. I'm wondering if the new structure would impede on that application being allowed, I guess. I'm wondering, I know it's something that you have to go through the state with rather than the town, but I'm wondering if that would be something that would ruin our chances of ever getting any sort of cosmetic help on our street, historically speaking.
I don't know the answer to that question, and I hate to say that you have the chairman of the historic district commission
I
here.
understand that, and I've spoken to Ryan about it, and I understand
don't-
that he's on the board of the town, but.
So, every year, I'm not even sure, to be very candid, how they identify the different sections of town that have become somewhat historic, or the village, like the Machine Shop Village
Right,
and
that was
those
my
sorts of things.
example, right,
We had an application several months back, like there was a property right on the cusp of the Machine Shop Village down on 3rd Street, and, it was a rather involved and contentious application, and, there was, it was not in Machine Shop Village.
Mm-hmm.
And, they had a landscaping requirement, or what could be cut or not be cut, and then, this particular property was outside of that, and they could cut what they wanted, so I really don't know the answer to that question.
Yeah, I guess that's just my concern, with
Sure.
the street changing in just one aspect, ruining sort of the chance of.
Of getting, inclusion
Yeah.
into a historic
Yep.
area.
My name is George Sharenda, and I am the chairman of the Old Center Historical District. I was also on the committee that put in the one at Machine Shop Village. Okay, it's a process you go through, and having another house has no effect on it. What happens is that once it gets into effect, and Machine Shop Village is a different animal than the Old Center. The Old Center is a lot more restrictive than Machine Shop Village. And again, it's a process you go through, and in the end, you have to go through town meeting. But it was many meetings to get it approved and get it done right. And I will tell you that how it started, if you want, is they went to the CPA and asked for some money to do some improvements in that area. And then when they got the money, people were saying, well, how do we control it? And so they backed into putting it into a district. So the easiest thing is see if they get some money from the CPA and then back into it, because that will get you through a little quicker. But it will have no effect on what houses are being built or done up until the day it goes into effect.
So the fact of having a new house that's built in 2016 or 2017 isn't going to make the slightest of difference?
No different whatsoever.
So if it's going to get in, it's going to get in. If it's not, it's not.
Right. And it's just like the ones at the Old Center that he was talking about. That was put in afterwards. And the reason we had problems is that he wanted to put in real nice contemporary type homes that just didn't fit for the Old Center. So, and again, when you look at those houses, they kind of fit in just like Ryan wants to fit in the neighborhood on Phillips Court.
I'll quote you on that, George, thanks.
All right. So any other questions? I don't want to, anybody that's been sitting here patiently, I don't want to deny anybody the opportunity to speak. But if we've exhausted our discussion for tonight, then maybe we could continue it to the next meeting for further discussion.
Then I'll make a motion to continue, Mr. Chair, to October 11th.
Motion, is there a second?
I'll second that motion.
All in favor?
Aye.
Okay, it stands continued.
Thank you.
Thank you.
Thank you.
Thank you all for coming. So, and we're moving on to the petition. Mr. Savastano, you're up to bat. Come on in, the water's fine.
Yeah. I still know how to swim. I'm just saying, it should cool off in here now.
Notice is hereby given that the Board of Appeals will hold a public hearing at the School Administration Building at 566 Main Street, North Andover, Massachusetts, on Tuesday, September 13th at 7:30 p.m. to all the parties interested in the petition of John and Lorraine Savastano for property address 273 Green Street, North Andover, Massachusetts, 01845, map 016.0, parcel 0062, North Andover, Mass. 01845, in the R4 zoning district. The petitioner is requesting a special permit from sections 4.122 and 4.122.14B of the zoning bylaw, which is a conversion from one family to a two-family in the R4 zoning district, is required from the Zoning Board of Appeals. Application and supporting materials are available for review at the office of the zoning department located at 1600 Osgood Street, North Andover, Mass. Monday, Wednesday, and Thursday from the hours 8 to 4, Tuesday from the hours 8 to 5:30, and Friday from 8 to 11:30 by order of the Board of Appeals. Applicant Manzi III, Esquire.
Okay, we have a public hearing open. Welcome. Just before we get started, how many people are here for this petition? Okay. And you other two gentlemen are on the last petition, right? Very good. So tell us about your project, sir.
Long and short of it is, my mom's not getting any younger. I lived around the corner. I lived 3 houses away for 20 years on the corner of Mass Ave and Trinity. I got married, my wife has a house, I had a house, my mother has a house. I'm the only kid. The house is gonna be mine. The inevitability of somebody leaving this earth gets a lot more as they get older. And I'm looking long haul is, what happens if mom did go? What am I gonna do? Am I gonna lose her house? Because I can't afford 3 mortgages. So the long and short of it is, my house was already done. It was saleable, sold it, bought my mom's house, but now I want my mom to have her own place that she can call her own. If I put it under an in-law, she lives in a closet. Quite frankly, it'd be way too small. The idea of this is that, at least if I'm gonna put money into a house, I wanna be able to recoup the money later on when I try to sell a house, and the house will become sellable because of the fact that it'll then be a 4-bedroom house, 4-car garage, and it's all on one lot. And that's the long and short of it, is I wanted to do it this way because it's easier and I can give her more space. I meet every other requirement. I meet every setback, every height requirement. I meet the grades, I meet everything. The only thing I'm here for is because it's required under the R4 for a special permit.
The conversion. The conversion's required.
Yeah, yeah. In order to have a 2-family, it comes under special permit.
So, let's just talk about what's changing as it relates to the aesthetics of your structure. You have a change to your footprint, but you're not seeking a variance.
I don't need to.
Because you can...
I meet all the setbacks.
You can build, you can build anything by right.
Correct.
It's just the conversion.
Correct.
Okay.
So the only thing you're doing is a 2-car garage?
No, it's a 2-car garage with an apartment over. There's a floor plan there, you'll see it.
Yeah.
It's in there. It's the 28 by 28 on the left-hand end.
Is it sloped down? Is that why the height's so down like that?
Yeah.
So your driveway's gonna go down?
No, the driveway actually meets grade. The grades are on there. Oh, I don't know, you may not have the new
I don't
ones.
have that one now.
I just had that done because we wanted to make sure that the Green Street wasn't gonna pour into my
Well,
my
I was
garage.
looking at this.
Which one are you talking about?
Yeah.
So it looks like it's sloped.
It looks like it's sloped, but when you actually look, Green Street comes down like this. Green Street follows that grade.
So the house is on a slope of...
If you're looking at the front of the house,
Yep.
where the garages are currently on the right-hand end
Yep.
is higher than the other end.
Yep.
By probably 4 feet, there's a guess, 3 feet. Pretty good slope.
So even though the height of that addition is the same as the height of the house?
Yep,
it's
we're
still
matching
low.
all the floors. We're matching the basement floor with the garage floor, matching the first floor, which is the living area, with the current living area's floor. And the roof lines are gonna match.
There should be a retaining wall.
So that's why I'm looking at the floor plan more than that. How big's that shed?
That shed's existing.
How big is it?
I don't know. Bigger than 8 by 8.
8 by 10?
I don't know. Bigger than 8 by 8. Been there for 20 years. Approved by the building inspector when it was put in.
It would affect this application.
Oh, well, I'll tear it down.
Okay.
I'm not worried about it. Believe me, I'm not worried about that shed one bit. If I get the other garage, the stuff that's in the
Just
shed goes in the
disclosing it all.
garage.
Just
Oh, yeah.
disclosing it all.
There's no worries for me. The shed has a rotted floor in it, so if you want to go look, stay out. The floor's rotted.
8 by 10 is allowed.
I know. I don't know how big it is.
Well, it wasn't picked up, so I don't think it, you must be under.
As far as I know.
Find it hard to believe they'd miss it, but
Really?
new guy? Yeah. New guy's pretty good.
You guys good?
All right, so I understand what you're doing.
If it matters, the intent of this is to design the kitchen in such a way that when the inevitability happens, all the piping is in the wall and can be capped, and I'm gonna turn that into just another section of the house. I don't really wanna keep it as a two-family because it's not gonna do any good for me. It's not gonna make me any extra money being a two-family. When I try to sell it, it's actually a,
You're confusing me.
in other words, my mom's going into it.
Yeah.
When the inevitability happens, I'm taking the kitchen out. It's gonna be just another section of the house.
So why don't you just do right now an addition to your home?
Because my
instead of
mother needs a
two-family?
kitchen. In order to put a kitchen in,
But she's not there.
Well, I mean, you know, you can have more than one kitchen
No,
in
my
the
mom's
house.
had-
that's not the issue. Your application's
I
for,
think
it's for two-family, because that's what I was told I had to do.
Who told you that?
Building inspector, building department, when I went in,
You've been around enough to know.
yeah, I have.
Okay.
And I'm trying to be as kind as I can, because when I go in for something like this, I go in and say, what do I have to do? What do you want me to do? And I'll go do it. And I've run that gamut.
I'm just trying to understand why you're not doing an addition instead of a two-family. If you don't want to use it for a two-family and you don't need the, I mean, what you're saying is...
It's not here, it's not as an income property, it's there for my mom, period. So
Okay.
she has her own place, that she can say, this is mine, I can lock it, it's my house. She gets her place, all by herself, she has her own everything. And then, later on, I'll take it all out, and then it just becomes part of the main house.
When she's no longer around.
When she's
it's
no
not-
I
longer
understand that, so why don't you just do an addition?
I think you're not asking addition, I think you're asking why not do a family suite, which is a,
Okay, I'm
which
not
is
even so much a
much-
family suite, because your mom's not going there, in there
But-
now. Is she in there now?
It's the extra, 'cause
No,
it's
she
the
lives
extra
with me right now,
Oh.
in the
The
same
family
space I'm
suite
in.
would be too small, is what he was saying.
It's way
Family
too
suites
small.
limits
Square
his
footage doesn't
ability.
allow it.
square footage
It would
requires
want more than
variance.
25%.
Square footage
Yeah,
requires a
it
variance.
just doesn't fit. She'd be in a closet,
This doesn't
although a
require
walk-in
variance.
closet, but it'd be a closet.
So, I mean, look, the application's the application.
It is.
I'm,
It is.
you know, it's allowed in the bylaw by special permit.
Yep.
That's what you applied for.
Exactly.
So, you know, okay.
There's others in the neighborhood. There's
The only
others.
access to this area would be from the outside, correct? Into this suite?
Yeah,
There's
yeah.
no access. However, if you were to change it at some point to sell it, to turn it into one house,
There would be an access door put in.
you would do that?
Yeah.
Through firewall and all, just?
Yeah, right through, I just figure out how to get it done and get it done.
Figure out how you were at it.
Yeah, no, it's going to be at some point, at some point that's gonna happen. It'll probably just come down through, there's a closet in it that can come out.
I think you indicated that there is a population of other multifamily structures
Yeah.
dotted around the neighborhood.
Mike Surrender owns a two-family right across the street, one house over. We have a house that is leased by the department. They've changed their name so many times. Used to be DMR. They're right across the street. They have 4 residents living there. The corner of Green and Mass Ave is a duplex. The corner of Trinity Court and Mass Ave is a duplex. There's a 3-family at the corner of Waverly and Trinity. I'm on the corner of Green and Trinity. So there's substantial amount of, more multifamily homes in the area. So not like I'm the only one.
Sure.
Plus I have McKeskey Meadows right at the bottom of my hill.
Right. I'll open it up. So, just, there's some abutters here.
Neighbors.
I think, does anybody want to be heard one way or the other, or?
Sure,
But
Mark.
I don't think you have to. Yeah, come on up, just name and address for the record.
I'm Mark Rogers, 19 Trinity Court. I've had the pleasure of being John's neighbor for
22 years?
22 years. And his mom for 22. She was there when we got there.
She was there
So
before
his
me.
mom for 22 years. So I really support this move. He's not going to do anything that won't be fitting in the neighborhood. There are multi-families, as John mentioned. And I want to do anything to keep him on the street, to be honest with you.
Okay.
One of the multifamilies was put in under our nose and nobody told us it was a multifamily.
But they're good neighbors, too.
They are now.
Yeah.
They are now. The one that put it in, different story.
So anyway, that's all I have to say.
Thanks,
All
Mark.
right, sir, thank you.
Completely support it.
Anybody else? Want to be heard? No opinions? You don't have to if you don't want to. I'm just giving you an opportunity to speak.
Come on.
We were just concerned about tenants. We just wanted to hear what it was.
That's not what it's about.
We were
So just
talking
hold-
about renters. and
Just
renters.
name and address for the record.
Emily Kivett, 288 Green.
288 Green.
Yeah, so it's kind of across the street to the right. We're in the corner.
It's under Robert.
Oh, you're at Ursula's old house. Ursula Savuza's house. Oh, okay. Now I recognize your face.
So,
I'm
yeah, so
sorry.
that's on the agenda as Holland. Is that-
Yes.
Yes.
Okay. Come on up. Please just come up to the podium. If you,
I mean,
or you don't want to come up to the podium? I'm not even going to make you. Okay.
Due to my work schedule, I was unable to come down here and
Yes,
look
sir.
at the plans or hearing that. We were just here for me for informational purposes. I didn't know what the plan was to go on that.
Stop over.
I didn't know if it was something we were looking to build up, maybe a couple, like a double decker type thing. I just wanted to see the plan.
Do you want to take a look at the
I can
plans
see, it
here?
looks like they're just building a garage off the left and an apartment above.
Yeah, I'll show it to you.
Basically.
You're welcome to take a look at these if you want.
I'll take a quick look.
While we're talking, this is what we're looking at. Take them back. I've seen them.
I did the siding on part of his house.
Okay. Anybody else want to be heard while they're looking at those plans? No? Okay. Well, it looks fairly straightforward to me. I don't see anything that, so you need, these hearings, you probably heard us say earlier, you need 4 votes. We have a regular member that's not here. Alexandria voted the first round, so I think, Denny, right? You do the next round. And then you, Mr. Weintraub, you get to do the final one, right?
Sounds good.
How does that sound? So, that way the board is comprised of 5. Because you have a right to have 5. You could go with 4 if you wanted to go with 4, but if you lose one,
Mr.
it
Chairman,
doesn't work.
go with 6 if you wish. Doesn't matter to me.
Yeah, well, I just
Doesn't matter to me.
want to make sure you understand how
No.
how this goes.
Just make sure I understand.
Make sure you
I
understand how
haven't
this
forgot
goes.
too much.
And we'll give them an opportunity to look at that real quick, and then see if there's any other discussion points in the interim. Are there any other discussion points?
I guess my only question was the difference between making it a multifamily and in-law. Is that the access from inside the house from one side to the other? Is that what makes it?
Well, I mean, there's probably different requirements in the bylaw for each in terms of, like, the in-law requirement, has different components that go with it, probably in size, and then it's not, still a single family. Then you come in, sometimes the size requires variance relief. The bylaw allows for conversions as well, so he just opted to apply into the conversion because it suits his needs better. So it converts to a 2-family, as far as the title goes, and then whatever, they can make the appropriate changes to the structure, get their building permits. And that's what it is. As opposed to the in-law apartment is always a single family. And then that has restrictions in terms of who stays in it, family members. That's the difference. He can apply for whichever one he wants or both.
Yeah.
This is what's before us.
Yep, this is just simply because it was easier to do this and meet the size requirement that I needed for my mom to have.
Well, what's interesting,
As opposed to the other.
what's interesting about that is the size of your lot, and so,
Yeah.
I mean, what you're proposing, you can build as right,
Yep.
by right as a single family.
I can.
You don't need a variance for that,
Mhm.
so, it's really the conversion of the dwelling from 1 to 2. That's what I see. Any other discussion? Do you want us to close this and vote on it tonight?
Sure. Quicker you vote on it, the quicker I can start building and put mom in there hopefully before Christmas.
Motion to close then, Mr. Chair.
Okay, we have a motion to close.
A second tonight.
There's a second? Okay, is there any further discussion on this project?
I think the only discussion that I might have, Mr. Chair, is that these kind of applicants become a lot simpler for me when it's just a special permit. When all of the setbacks are satisfied, that makes my analysis the scope of it.
Sure.
And I'm really encouraged by that. Secondly, so speaking just on a special permit itself, another thing that's encouraging is that there's more than a couple of multifamilies in the area. It doesn't appear to impact negatively the character of the neighborhood, and we have we have limited public comment, and the only comment that we've heard has been positive and supportive. So that's certainly that's persuasive to me.
Okay. All right, so then we'll hear the motion.
I will make a motion to approve the petition of John and Lorraine Savastano for property address 273 Green Street, North Andover, Massachusetts 01845, map 016.0, parcel 0062, North Andover, Mass. 01845 in the R4 zoning district. And then the motion is to approve a special permit from sections 4.122 and 4.122.14B of the zoning bylaw conversion from 1-family to a 2-family in the R4 zoning district as required from the Zoning Board of Appeals. Referencing, Mr. Chair, a plot plan of land number 273 Green Street, North Andover, Massachusetts, prepared by Sullivan Engineering Group, LLC. The date of that is July 12th, 2016. And attached to that are plans labeled merely Savastano Residence. There is 1 a front elevation, 2 a rear elevation, 3 a left elevation, 4 a right elevation, 5 a basement plan, and a first floor plan as the 6th. They're not numbered. Those were just for my convenience, Mr. Chair.
Okay. Motion, is there a second?
I'll second that motion.
Here, motion and second, okay. Mr. Koch, you in favor of the motion?
Aye, Mr. Chair.
Okay. Denny?
Yes, sir. Yes.
Yes. I am also in favor of it. Ms. McIntyre?
I am not, no.
Okay, it's approved 4-1. We'll issue a decision within 14 days. It's a 20-day appeal period.
All right.
Okay.
Good luck.
So what do I wait for, Al?
Very good.
What do I, just 14 days, I get something said to go?
No, so we'll issue a decision within, we have 14 days to issue a decision that gets time-stamped at the clerk's office, Joyce Bradshaw's office. Once it's time-stamped there, that starts a 20-day appeal period. Once the appeal period has lapsed, you can then apply for your building permit.
We're looking for another month?
That's how long it takes. That's the,
Does it get notified when it's actually signed? Or do you have to follow up?
No, you get notice.
So you send the decision to the applicant. Okay, so she'll give you notification.
We'll
So
tell you.
once
We'll
that-
tell you as soon as it gets time-stamped.
All right.
And then you can start. That starts the clock.
Thank you.
Okay, you're welcome. Okay, moving on.
Notice is hereby given that the Board of Appeals will hold a public hearing at the School Administration Building located at 566 Main Street, North Andover, Massachusetts, on Tuesday, September 13, 2016, at 7:30 p.m. to all parties interested in the petition of Pond Pasture LLC for property Pond Pasture Lane at the rear of 575 Osgood Street, map 36, parcel 002, North Andover, Mass. 01845, in the R1 zoning district. The petitioner is requesting a variance pursuant to section 4.136 and 4.136.c. Romanet 2.3 for construction of a new permanent structure in the R1 zoning district. A variance is requested under section 4.136, Watershed Protection Division 3, the uses and building requirements. C. Romanet 2.3, which is the non-disturbance buffer zone of the zoning bylaws. Application supporting materials are available for review at the Office of the Zoning Department located at 1600 Osgood Street, North Andover, Massachusetts, Monday, Wednesday, and Thursday from the hours of 8 to 4, Tuesday from the hours of 8 to 5:30, and Friday from 8 to 11:30 by order of the Board of Appeals, Albert P. Manzi III, Esquire.
Okay. Welcome. How are you?
Good evening. Good, thank you.
So, Mr. Capola, right, we've met before.
I'm Ken Costello with SMRT Architects and Engineers out of Andover, Massachusetts.
Okay, so you probably prepared a lot of the information.
Technical
as it relates-
documents,
the
yes.
Technical stuff, sure. So tell us about your project.
Can I give you a brief overview first, Al? And then Ken will take it over from there on the technical aspects.
Sure.
So Edgewood had looked approximately 2 years ago about expanding our mission because we feel as though we have a very special mission there over at Edgewood Retirement Community. The Rockwell folks, the family, approached us about selling that parcel that they had up there that we're talking about, the pond pasture parcel. We came to an agreement with them on the purchase of the property, and then we started conversations with the planning board about what we could potentially do up on that site. And what you'll see when Ken presents is it's a culmination of the conversations with the planning board. It's also with conversations with the technical review committee. And what we're looking to do is, this is a dementia facility. It's a 40-bed, we call it a small home. And what the small home actually interprets to is there are individual pods that will house 10 residents each. And with folks with dementia, the philosophy has changed from the typical nursing home style with the long corridors, et cetera. You're trying to draw people out and bring them to make it a community for them within that space. So that's why we're limiting it to 10 residents per pod, because we're going to create exactly what it sounds like as a small home. So the bedrooms all tie into a living space, et cetera, with a kitchen. And there'll be a separate kitchen in each building, and they'll have their meals together. The folks that work in that space will also have their meals with those residents. So we're really trying to bring that whole piece together. And we're not going to introduce like a custodian, et cetera, or maintenance folks into that space. It's going to be a universal worker, because you're really trying to maintain continuity, because anything that kind of skews out of that is challenges for folks with dementia.
Yeah.
Edgewood, back when they started in 1995, they put aside 29 acres, 29 and a half acres into a conservation restriction, which is the piece that's down by the pond. Back in 2004, They added another just under 10 acres, which is where the horse barn is, where we did a conservation restriction with the trustees of the reservations. And then as recent as 2004, they added the John Osgood house as a conservation restriction as well. For this piece that we're looking at, the Rockwell piece is a little more than 20 acres, 20 and a half, I think, is what the number actually comes out to be. We're looking at taking 5 acres of that, roughly 3.2 is our development piece, and then the balance would be in open space. That balance of 15 and a half acres, we've already met with the trustees of the reservation. They've approved taking this in as another conservation restriction within that parcel. So we're going to have about 105 acres of total property. Of that 105, 58 of it is going to be under conservation restriction. So we're working out those details with them, which will naturally become part of the special permit with the planning board. Which
have you filed with the planning board yet?
We have our first meeting next Tuesday with them.
Okay. That's good
So
to know.
this is our first step, naturally, for the watershed, for the variance. And then our second is to get a special permit or enhance our special permit because Edgewood already has one as a CCRC, so.
Right. So I can't, obviously, this is a pretty sensitive site, by the nature of its proximity to the water.
Yep.
To the watershed. You guys already know that because you've been dealing with it for a long time. So you've had some informal discussions with the planning board, but you haven't had a public hearing with them yet, right?
Correct.
That's correct.
We've submitted to them, we've been getting the comments back the last couple weeks, and we have a hearing with them next Tuesday.
I actually know this parcel from the lake from when I used to go fishing, because the Rockwell had an old cabin down by the lake shore, I think called Getaway 1 or Getaway 2 or something. I haven't been out there for years, but it's a very, nice piece of property.
Yeah.
So I'm sure the planning board is going to be, they've always worked with Edgewood in the past. We've permitted various projects for you guys in the past, but this particular piece is sort of a little bit closer to the lake than previous ones. So I'd be very curious to hear what their comments are in the context
Sure.
of.
Well, the proposed building right now is over 700 feet from the proposed development is 700 feet from the lake.
From the lake?
From the lake.
Okay. Is that the minimum? That's your minimum?
That's the closest.
Yeah, I
point.
don't think you can get much closer than that, right? Without some kind of waiver? They have a bylaw?
With
for that?
additional special permits, yes.
Yeah, okay. Yeah, so I'm trying to orient myself on your plan here.
I have an overall plan if you'd like to see.
Yeah, that'd be helpful. Is the whole site, okay, because what I'm trying to figure out is where your proposed structures are in relation to
This
this.
is Edgewood right here.
Yep.
So, north is up, so this is the lake.
Yep.
And this is the Edgewood, back of Edgewood right here. And so the Carolina Way is right here, which the cottages are on, and then it comes up back to the service area back here.
This property has access from the road, right, from the corner of Stevens Street and.
From Osgood Street.
In Osgood Street, there's an
There's an easement.
an access way, right?
There's an easement that runs all the way down from Osgood Street all the way to this parcel.
Right.
So I think I heard you identify some features of Edgewood. Where is where these pods are going to be approximately? Okay.
Yeah, so that was my question, was what was your I was trying to orient myself in terms of that proposed
Again,
restriction.
This is the parcel right here. It's 20 and a half acres, and the proposed is at this higher up portion here that's adjacent to the.
So that's the down, so those slope lines, right?
These are going down.
Those are going down. The closer the
About
lines.
70 feet.
70 feet down the hill.
Yeah.
So Ken, why don't we show them this one as well, which
Yeah.
actually shows the
It's a different
the
scale.
structure, different scale. And so you know where the trailhead access is?
I think so, yeah.
This is the trailhead access up here, okay, to get to Half Mile Hill. This is where the easement runs through on that, for the pond pasture that runs down to Osgood Street. So we are in the furthest corner away from the lake.
Sure.
As well as what they had asked us to do was stay as far away from Half Mile Hill as we could. So that's how it ended up in that corner, and that's how we pushed it into where it is.
How much of a variance you asking for?
The variance is requested to build a building in the non-discharge zone.
Correct.
So that you're asking for
between those
100%.
between those two red lines.
Yes, we do, right. This is the non-discharge zone.
Right.
And based on the bylaw, we can request a special permit only after a variance has been approved for building within the non.
But you filed with them anyway.
Yes.
Yeah. I mean, I know that's what the bylaw says, but I think that the board is certainly going to need some public hearing feedback or something from the planning board, because it's totally within the non-discharge zone, right?
No, not the entire building. This is this section.
Just
itself.
that section?
The responses we've been getting back from the planning board so far for our application have been technical, stormwater comments, fire, checking on fire department access.
Lisa Eggleston, it went out to Lisa Eggleston? Is that who's doing that?
Yeah.
So
She's done this. She did the full property before.
Both TEC and Eggleston.
did they issue their findings on stormwater yet?
Yes.
Okay, so you have all that?
Yeah, we've got it this week, and we're basically responding to it now.
Okay, yeah, I mean, I think that's something we would need too.
There's no other parcels on this land that you can build on. I mean, it's a rather large.
There is not, because of the conservation restrictions that exist
On the existing campus.
on the existing campus.
It's just really close to our drink. I mean, it's right there.
So what is it, is that,
Right on the lake.
I'm curious in knowing what the tree line is gonna look like too, if you were to get this variance.
The tree line from the lake?
Well, yeah, the size, the size of the structure.
These buildings are single story.
Yeah.
So the height is about 35 feet. So we're underneath the zoning regulations for height.
Okay.
The existing forests around it, which will remain here,
Mhm.
some of the trees are 80 feet tall.
This is all currently wooded though,
Yes.
it's not open like
Nope.
Half Mile Hill.
Correct. It's wooded.
Yeah.
Currently wooded, and it's wooded basically the entire site, all the way down to the lake.
How many beds is this? Our pods,
So
or
there's
I don't know. What do you
10
call it?
beds for each one, 10, so there's a total of 40 beds.
40 beds, so
Yeah.
40
40
potential residents.
So how big's the structure?
About
38,000 square feet in total, so each pod is approximately 7,000 square feet. And then the center area is center common spaces, so there'll be a gym area, a workout area for the residents, a salon, gathering spaces, some offices to do their office work, et cetera.
I mean, it's a great facility, we know, we all hear, well, at least I hear good things about it all the time.
Yep.
I'm trying to digest the scale of what we're doing, within the non-discharge area and the proximity to the lake, And there's probably some agreement that controls with the town, right? The town gets revenue for so many different units that are created.
This isn't included.
This taxes, Edgewood pays taxes.
They don't give the,
Last time we permitted something for Edgewood,
yes,
there
this
was,
is not. This is part of Edgewood?
This is part of Edgewood.
there's a revenue stream that is created for the town, correct?
Yes.
Yeah.
Just a point of information, I'm Paul Hitchram, I'm helping
Yes, sir.
Edgewood. I'm actually the managing member of Pond Pasture LLC. This variance
Which owns the land, right?
is the triggering mechanism to get before the planning board. This isn't a variance in the true sense of relief from something.
Mhm.
It's your view of the project and your permission to construct the improvements in the watershed that is of no force and effect until you go to the planning board and get a second permit, which is the special permit. Much like the Penteca Bank.
Yeah, we permitted that.
Yeah.
But I think in the context of this project and its scale and, the circumstances relating to it, I would submit that you could get before the planning board, and you could open your public hearings and get some comments, but they wouldn't necessarily render a decision until our decision had been rendered.
Oh, I suspect, Mr. Chairman, that's probably correct.
And I know, sometimes, I sort of hate the aspect of the bylaw where the Board of Appeals is forced to operate in a vacuum, and we're supposed to make a decision on something, in this context, and not know what's coming from the planning board in terms of what what our decision
Well,
means.
Clearly, the intent here is to not have you operate a vacuum, but simultaneously before both boards.
That's why I think it's great that you
And
filed.
this is the result of 7 months of planning
Really?
by the specialists to pull these improvements. This is 20.6 acres,
Yep.
on which is going to be less than 3 acres of development, and the balance goes to the town. So
Can I ask you a question? How many for how long have you been going before the town's technical review committee?
We only had one meeting with them.
You had one?
And now we're meeting with individual department heads.
So the technical review committee is sort of the administrative type board that looks at these projects from the administrator's perspective, and they sort of pick up.
The boards, DPW, fire, police.
'Cause we're not on it,
We used to be.
That's why I'm asking.
Yeah.
Yeah, so it's all your department heads. Building
used to go.
department, et
Sure.
cetera.
Sure.
Yeah.
And they give you
And then
guys.
Jennifer Hughes from Conservation is part of that as well.
Sure.
So yeah, it's the whole group of folks that offer their opinions and.
They give you
us
feedback
Yeah.
based on the bylaw and.
Yep.
And you had one of those?
Yes, we've had one, and then we're meeting tomorrow with Building and Fire for a second time. We met with Board of Health as well, and then we'll subsequently meet with them again as we finalize the kitchens for the facility.
What's the value of the increased revenue to the town once the project like this is completed?
I don't have that answer.
This is a parcel that is developable. The Rogers and the Stevens, this is a 20.5 acre parcel with a 60-foot right of way.
Right.
It can be developed for estate lots.
Right.
It has development potential. The town was a possible buyer. Edgewood's a possible buyer. Edgewood bought it. The town manager was thrilled that we bought it because we saved the town $650,000.
He likes revenue streams, though, as I recall. I don't think he
No,
cares so
no,
much
no.
about open space.
That's
woods.
saving the town the cost of buying it was just step one. So
Yeah.
So it's a
We're doing the town a favor.
parcel that the town would like to see minimally developed.
Yeah.
I guess that's the point.
No, I think those are valid points, Mr. Hedstrom. Can you just kind of show,
Sure.
where is the break between, you talked about a conservation restriction for the trustees of the reservation. Where is that in relation to this parcel and what you're proposing?
So approximately this area right here would be the Edgewood development. The remainder of the parcel would be the.
You mean a new
conservation
one, Al, or
restriction.
the existing?
You had talked about a new one that you had talked to
Yeah,
trustees, right?
So this
So
is
Ken is
the
correct.
approximate locations, of about 4 acres of land
Yeah.
that Edgewood would use, and then the rest of it would be conservation restriction.
The balance of the 15 acres is all conservation restricted.
Interesting.
Right down to the lake. And the trails that are existing will be open for public use as well, as are the other trails that exist on Edgewood's campus. So it connects folks from Ware Hill right up to Half Mile Hill.
So you want to propose deeding that restriction to the trustees of the reservation, or you're going to deed it to the Conservation Commission?
Trustees of the reservation.
The Conservation Commission wasn't interested?
Trustees, they asked us to go through them first, and they accepted it.
They have all the other
They have all the
restrictions
other
on
restrictions.
Edgewood property.
But they don't have Half Mile Hill, do they? Doesn't this about
I
Half
believe
Mile
that's
Hill?
not- I believe that.
I'm not sure.
That's the town's.
That's Conservation Commission.
Yeah.
Yes, that's why I was just asking. If Half Mile Hill was the town's and
This
you were...
is Edgewood's property. Edgewood's property comes right here, so this is Edgewood's property. This piece right here is all conservation restricted, and that's through the trustees.
Yes, sir.
That's the 30 acres that
Well, thank you.
was first developed.
That shows all of the land. This is the last piece of the puzzle in the town's view of the land. The town owns most of the open space. This is the last piece that was not owned by the town.
But I don't understand if is this supposed to be town of North Andover?
Yeah.
And this is the abutting parcel?
That's the parcel we're talking about right here. Yeah.
Right. So why would this little, well, what, I don't mean to say little, the section that you're carving out,
Mhm.
why would the town want that to go to the trustees as opposed to their own, if it abuts property that they already control?
It abuts the it abuts the land under the trustees also.
Where's the trustees parcel figure? I'm sorry, I don't,
The other 88.
this one?
Yes, basically this whole section here.
Okay. And they're a great group, I'm just trying to figure out.
This is the Edgewood parcel that goes here.
I see.
And so they have that piece, and there's other pieces up by the road too.
Basically, the land that is owned by Edgewood will be encumbered by conservation restriction, so that the town has all of the land except for the Edgewood land, which has the conservation restriction, and will have the conservation restriction. Has one in place for the existing campus, and will have one in place for this one. So that takes care of the entire side of the lake. There's no missing pieces of the puzzle.
Yeah, but the holder of the restriction is not the town, it's the trustees of the reservation.
Trustees, right.
So they have custody and control over the enforcement or whatever. They hold the restriction.
That's right, but they run an enforcement mechanism, it's the same benefit,
Yeah.
there's no maintenance cost to the town.
Jennifer Hughes actually walks the restrictions as well.
Yes,
Yep, Jennifer walks them even though they're under the trustees of the reservation.
sure.
She does as well, and they do an annual inspection of all of the conservation restricted property.
What's the distance between the lake and the property?
Um,
Or what would it be?
It's approximately 700 feet.
I can get by.
So would you be able to see the structures from the other side of the lake?
From the lake?
Or would they be hidden by the
I don't
trees?
believe so because of the height of the vegetation out there.
Yeah.
Because the slope's changing, right? So
Yeah, it's dropping down.
Yes.
Yes, you're right. It drops down as it goes down, but again, the clearing will be to approximately here. And again, this vegetation out there, the trees are 80 feet or so. I mean, there's some oaks that are
Monsters.
I think I'd like to get out there at some point and kind of orient myself with this, what's going on. I'd like to see it.
What's the green?
Wetlands,
Pond, oh, by
flag
the way.
wetlands.
Okay.
You gotta stay away from those.
Yes.
Yep.
Yep, we're actually outside of all the conservation jurisdictional areas.
Don't let you film them anymore.
Snakes?
We're not even
Are
within
they out there?
we're not even within their
Oh, I'm not-
jurisdiction.
So you had asked about you're confusing the Edgewood donation to the town as opposed to revenue.
I don't know what you call it,
There
but
was
it's a
two
stream.
different,
Yeah, I'm not looking for it, I was just wondering, I remember seeing an agreement with the old filing that there was, and I was just wondering what, if anything, there was. I'm not
it was an
looking for it.
incentive.
You know, if I'm mistaken, am I mistaken?
I wasn't at Edgewood at that time, so I certainly can't answer what was done back then, but there has not been any conversation about that at this point.
We can develop that as we go through the planning board process.
Oh, okay, so there's no agreement then?
Not as yet.
No.
Oh,
No.
Yeah.
But we're just starting the process because we're before the appropriate board, which is you guys.
Yeah, interesting. This is an interesting project. I mean, it's certainly well thought out, and I can tell you put a lot of time and thought into this.
Just as a point of information, the improvements are literally on the top of the hill, pulled as close as possible to the meadows, and that, you know, if you walk the site, you'll see it topographically pretty flat, and then back and starts to descend to the lake. They moved everything as close as possible to minimize tree cutting and topographical issues, pulled it outside of all of the wetlands concerns, all of the
And
conservation jurisdictions.
You see this lightly shaded area? That's where the existing meadows is right now.
Mhm.
And then this is
The bonds.
the access road that goes down to service Edgewood. So we, as we said, we kept it as close as we could.
So let me ask you this, is there any more land you can develop on this property after this?
Nope.
No.
Does this be your final application as Edgewood, well, beside if you...
I think you asked him that last time.
I did.
Well, in fairness to them, they didn't own it.
Yes, you did not.
You didn't own that.
Is there
Okay,
any
but you guys aren't
property
gonna buy
owned?
any more, right? There's nothing else for you
There's
to
nothing
buy in
else
the
to
area?
buy?
No. But if you think about this use versus a couple of estate houses for $2 million, this is a positive benefit.
I don't know if I'd I don't know if I'd buy a $2 million home.
Well, I mean,
Well, there are some people that would.
Yeah. But I don't know if I can. No, that's not the option. Oh, I know I can't.
So
but-
what is the scale of the property that you are disturbing? What is this, how much land area are you,
Approximately 4 acres clearing.
4 acres of clearing?
But there's only, it's 20, the improvements, the building is 20,
Yeah, well,
It looks like a substantial amount.
And how big is the building?
Yeah, and this is a different scale than that as well.
Yeah.
Than the lot.
28,000 feet.
this kind of gives you a scale when you look at, parking lot sizes and such. Again, this green section here is at a different scale as that piece of wetland on the.
So I know there's all different scales, and I'm not good at
Well,
this stuff.
I apologize for that.
That's
because-
okay. Help me out on this map here. This old,
Just dimensionally, what the building.
just show me kind of like where the disturbed area, where the 4 acres is.
Right up here,
Oh,
right up there. So it's at the end of the pond to pasture
okay,
easement, so it's right in this area.
okay, so 4 acres in that chunk.
Yeah.
So that's leaving approximately 15 acres.
Yes.
That will go into a conservation restriction.
And all the, if you look on the existing conditions plan that we submitted, there are trails out there. The trails, all the trails will remain, and access to those trails will remain.
And it doesn't cost CPA. CPA doesn't have to, compete to buy it in that context, right?
Right.
Because,
And the town has an amazing fund they generate every year, as we all know. We all pay the taxes. And they have lots of demands on those funds, so.
They do.
We're saving, this project saves the town the $650,000, because the town didn't want anyone else to buy it. The town was okay with Edgewood buying it, but nobody else. So,
And we didn't want anybody else to buy it either.
part of this is there is an ambiguous
yeah.
easement right in the town today to get to some of these areas. This undefined, this is a pond pasture easement, it's unimproved.
Sure.
One of the things we're going to do is grant a specific right to the town to travel over the roadways that exist as they are ultimately improved by this little spur into this project, we get all the permits, so that there is the half-mile hill parking area and rights of the public over the roadways to get there, so there isn't any more ambiguity.
Sure, sure. It's a very interesting proposal, really. Because, I'm sure all of that has weight.
A lot of benefits, mutual benefits here.
Well, and as you know, Edgewood is a not-for-profit organization as well, which is important for us.
Right.
And dementia housing is in demand in the Merrimack Valley. If you've, looked at anything that is occurring with that population, it's definitely a need. And these 40 beds are just a very small amount of what's going to be required in the future.
You said it's a not-for-profit or a non-profit?
Yeah, it's a non-profit.
Non-profit.
Non-profit, okay.
Right?
I actually work for a not-for-profit company, so.
Difference.
Yes, I was just curious. You
Yeah.
said it quick, so I was like, it's just,
What's the age for residents?
Our average age group is in the mid-80s. And it's a very active community. If you walk
So I may be the
half mile,
youngest one.
you're the youngest one.
We'll start there.
It's a very active community. They hike the trails, they, snowshoe, they kayak on the lake. I will say that when the planning board walked the lake, they couldn't have been complimentary enough of Edgewood as well as Fort School for the way that we manage the lake, because it is very important for us to maintain that. And, we make sure that we pay attention to detail on that. We don't allow any trash down there, et cetera, or any of those things. So, I think we have about 340 residents that live on the campus.
Lock facility.
It's what?
Lock facility.
This is a dementia unit, so 3 of these buildings, 3 of the pods will be for dementia care, and those will be secured facilities. The 4th one, we're looking at potentially being a medical, not medical in the sense that they need medical care, but they may, be in a wheelchair, they can't be on by themselves, if a spouse passes away or something like that. So there'll be that group that will be independent as well, that will be in one of those pods. And then the balance, it is a locked facility, and, with those gardens that we're gonna have there, those will all be locked as well, with wrought iron railings, because you're trying to get these folks to enjoy the beauty of that area as well as everybody else, because, that's what they need to help. To give them the best quality of life is what the goal is.
And one of the things that Edgewood has determined is well care for dementia housing could be, as I tease my wife, I said, we'll reserve a unit for me, and you can be in the main house, because, you know, if the husband or the wife needs dementia care, but the wife is in the apartment, they're within walking distance, and you know, there's a family component to having dementia special housing on campus, adjacent to the nursing home, adjacent to the apartments. It really is, sort of finishes all of the needs that those of us that are pushing 70 may need in the next 20.
Is it the same concept in the way that the rest of the facility works in terms of ownership, and then with the dementia unit, or is it just an additional service level of care? How does that work?
It's an additional service level. Well, currently, folks get services in their apartments.
Yes.
They can get service in there. If they don't want to move into the nursing home, or if they don't need to, they can stay in their apartment. And so when you look at the cost of the extra services that they may require if they have 24-hour care, it becomes very expensive for them. And so this would be a step in between that. So they still can elect to stay in their apartment if they want to in the independent living, but they will be paying more money. This is a less rate than that, so that it will help them, you know, to continue. So by having the so it's staffed 24/7 is what the building.
So it's more of a nursing home facility as opposed to the apartments?
It's not a skilled nursing home. That is the Garden View and the Meadows.
Right.
So this would be more of an assisted living facility. Edgewood is independent or skilled nursing, so this would be the assisted living component of that. So they need some assistance, but they don't need skilled.
But there's no apartments or suites or anything, so it's
No.
just,
they'll have a room, and then they'll have a common space there'll be a large common space, as I say, you know, a dining room, a living room. There'll be a kitchen where they will, you know, have their meals together in that dining room, and then there's other pieces as part of that will be within that space. So it's creating a community within that pod for them, for those kind of folks.
So
And trying to make it a home. We haven't figured out the pod, we don't like, you know, some of the other names we haven't quite figured out yet, but for right now, that's what we're calling it.
what's the movie with the,
Pod makes me think of
pod?
prison.
No,
Sorry,
where was
but-
that movie with the big eggs, the pods?
Invasion of the Body Snatchers.
No, there was another one, with that, from Miami, Cocoon, yes. I'm aging myself,
I
thank
mean,
you.
it's based on called a small home concept, and so, you know, it is a home.
Yeah.
They have, you know, basically, it's just a 10-bedroom home.
And we can prepare plans that are on the same scale, so you show the minimal impact of the project against the 20.5 acres. So you see the building footprint on the same scale. You know, you're seeing a building footprint on a large scale, different from the scale of the entire 20 acres. So
Yeah, I mean, I think that, you know, that helps a little bit,
yeah, just so
because,
you see the mass of it in relation to the 20 acres.
yeah, I think that's helpful. I mean, you know, it's a very interesting project, you know, I'm only one person here on, you know, one voting member, but, you know, one of the things I'd like to be able to do is a little diligence on your project as it relates to some comments back from the planning board. You know, they're supportive of it, I suppose, where you've been working with them. I'd like to touch base with conservation a little bit to understand, you know, where they were on not wanting the restriction to go to, you know, the NACC as opposed to trustee. But really, I mean, Lisa Eggleston's stormwater report, I think, you know, we would need for the record, because it really drives the variance, you know, in terms of the waiver from the non-discharge zone, right? And I'd love to be able to get out there and walk that site before the next meeting and really grasp what you're doing, because the plans are very helpful. But sometimes, you know, we do drive-bys with different things, and you need to see it, you need to see how your vote impacts the community. And you know, if we could make it, you know, anybody else that would want to go too, get out and just kind of see this area, you know, and the slope, understand the slope and what that 700 feet means to the lake. Really do our due diligence, you know, because I think it's an important project. I think it's a worthy project, and, but, you know, we're always like that first stop, you know, and everybody else, and the land use relies on our decision. I always want to make sure I'm making the right one, because, you know, I'd hate to.
But here's the thing, Al,
Yeah,
with
what's
the
that?
last stop as well, in the event that anything else has changed, this variance becomes null and void, because they'll have to come back to change their variance.
I've been doing this as, you know,
It doesn't, this
it
has
doesn't,
nothing
that
to do
doesn't
with time. I
happen,
mean,
that doesn't
yeah,
happen a lot. I mean, I know how this, I know, you know, when the board grants a waiver, it grants the waiver. And so, you know.
Because the planning board always listens to the zoning board.
You know, we're gatekeepers, right? We're gatekeepers. I mean, the
I mean,
bylaw exists. I'm not saying that there aren't a lot of positives to this project, because I think there are, quite candidly. I think there are a lot of positives to it. But, you know, project of this scale, to not do a little bit more diligence, for me personally, you know, I think is reasonable. Quite
And
candidly.
Al, if I can just clarify for you regarding the trustees of the reservation. The first comment was that we would go through the trustees of the reservation.
Yeah.
They had denied the town on some of those pieces that Paul showed you.
Yeah.
You folks had applied to them to absorb some of that land, and the trustees denied it.
Yeah.
So our first step was to go through the trustees, knowing that conservation would take it in as a conservation restriction. So we went through the trustees first, because
Sure.
that's how the other restrictions were.
Sure.
We knew that our fallback was we would go to the North Andover Conservation
Sure.
Commission if need be. So where they approved it, there was no point in us going any further. So
No,
I just want to clarify that for you. That was the first approach.
Everyone has been pleased, and I know this board will be pleased once they understand the project in totality. You know, you get almost 21 acres, and you get less than an acre of development.
Yep.
All with the design of trying to be respectful, as Edgewood has been from day one,
Yep.
of the lake, and pulling it as far away as you can, 700 feet. You know, so it's really a lot of effort, and we will continue to make sure we get the walkthroughs, and, you know, whatever you all need, happy to provide.
I mean, like I said, I'm only one, but I something like this that is, you know, very permanent, and I want, within the watershed and close to the lake, I want to make sure I fully understand the impact of my one vote, you know, and I would encourage the other members to, you know, want to do the same. Can't speak for them. But, you know, that's where I am, because I can tell how much work has gone into this, and I can, you know, the 15 acres is substantial, you know, and I really want to understand how that's going to work too, if this is waived in its totality as presented. I want the board, and I want there to be in the record, quite candidly, what the stormwater impacts are that you're asking us to waive. You know.
You'll have a full file, whatever.
Right, I mean, we're still working that out with Eggleston. You know, we got her responses, we're reviewing her responses and revising our design in association with her comments. And we intend to, you know, work through that process, through the planning process.
Sure.
We know that's a requirement. DPW's had some comments regarding.
But who's handling the stormwater for you? Conservation and planning? Who's going to control that?
It's planning.
Planning's going to control it.
Yeah.
So, because you don't have a flag at conservation because you're outside.
Correct. We're outside of the jurisdictional area.
Okay. Well, I mean, so, you know, my initial take would be that we would ask you to consider continuing to the next meeting and hopefully getting this all wrapped up. You'd be the first on the agenda for the next meeting. You wouldn't have to wait because you waited so patiently tonight. We try to keep everything moving. I went out of order tonight. I beg your pardon?
We much needed Mr. Sharonda.
I have no doubt. I have no doubt. Oh, yeah, right, we couldn't. Right, you might be second after Mr. Sharon. I stand corrected. Although maybe you could go ahead of him quite candidly.
They'd be quicker.
There was a family tonight that had a daycare issue, so we were trying to accommodate that as well. But if that's something you guys would be willing to work with us on.
Yeah, I'd like to line up a walk with whoever would like to go sooner rather than later if you can.
Yeah.
We can do multiple walks if you'd like to do that.
Sure.
Saturdays would be great.
Yeah, I mean, I don't think we all have to go as a group. I mean, you know, we could.
I'll put on my walking
whoever works.
shoes.
Well, the site is open, to the public. People are using it now.
Well, we'd want to, I mean,
Yeah.
if I were to go, I would want to go with a
Is it
representative,
flagged?
you know?
Yes.
There are some flags, yes.
What color would your,
What do you think?
like, do you have the building all flagged out?
Not in its entirety, no.
Yeah, you want to see that.
But if you folks, when would you like to go this Saturday? Does that work for folks?
I don't have my calendar with me, but we could communicate through Merrill, you know, or I could set it up with you directly.
That's fine, you just let us know when you want to do that, but
Yeah.
more than happy to have you walk the site.
I don't want to, you know, frankly, I wouldn't ask you to go if you don't work Saturdays. I'd try to meet you during the work week,
It doesn't matter to me either way.
you know.
Well, it gets kind of dark early or during.
Unfortunately.
At times it does, yes.
And I don't personally want to get stuck in the middle of the woods when it's dark.
Well,
It's
then,
just me.
don't go at sunset.
Well, I'm not going by myself.
Well, yeah.
It's a good lord, you know what?
There's a lot of.
But I would like to see the
So, I mean, I think if you had a time, you know, we don't want to inundate you, but I mean, you could obviously make, if there was a time that was ultimately selected and it didn't work for you, you could make your own time and go. You know, because maybe I might have to hit you during the week, you know, some morning or some afternoon
Tom's
to,
office is 400 feet from the spot.
you know.
You want to email me individually? How would you like to do that?
That'd be great. I'd like that, please.
Thank you.
You're gonna be walking a lot, I'm guessing, possibly.
So are you on the facility? Are you there?
Yep, I'm the director of facilities.
Okay, so you're there all the time.
I'm there all the time.
Well, I would
I didn't give you anybody else's
I would
time.
caution the board against emails because of the open meeting law, but I would suggest maybe a
To
call.
arrange a
You can call
walk?
me.
Or just a call or maybe not the open meeting law, but just maybe do it through Merrill. But either way, whatever you want to do. I think as long as we can get out there, my whole point is, as long as, I want to really just see the impact and understand the site.
And I'll give you this. That's the existing conditions plan, so just to get you oriented, this is the parking lot for Half Mile Hill. This is the trail that goes up Half Mile Hill. So if you come off that parking lot, there's these 3 trail spurs. This dark dashed line is the limit of the work.
So what will we find in the site in terms of markers?
I'm not sure what's up there.
What would be the markers that we would find that would show the impact area?
There are some flags that show where originally when we first looked at this, it was going to be 2 separate buildings. When we did the engineering and we wanted to get it away from Half Mile Hill as far as possible, and then we made the determination that there are going to be times when these folks are going to be gathering together. So that's why we connected the buildings, so that they don't have to walk outside to be able to do that, so.
And that pulled away from some of the trees you want to cut down.
Oh, it pulled us tremendous, a huge difference away.
Yeah.
The whole area is wooded though, right?
Yes.
Yes.
So the slope, you know, so I mean, you know, so I would want to see exactly the slopes, you know, and how that's working. But this is great. We'll keep this in the file with Merrill.
I can tell you right now, the proposed, there's a knob here, so the proposed is we're going to be coming in pretty much at grade here, sloping down. The building sits here. The site will be filled at some point on the backside, and there's going to be a cut on this side here to basically level it out, because it is one level. The building is one level.
Yeah. You're going to have cuts, I can see that.
Yes, there'll be cuts, I said,
Yeah.
up in this area, and then there'll be fill on that end.
Okay.
But you'll see proximity to the stone wall. I mean, it's off 30 feet off the stone wall.
Right, yep.
Any other comments, you guys? I can tell you there was always very good fishing over there. Years ago, I used to, I'd take the boat from one side of the lake to the other when the days when you could do that. And
You were just probably because you continue to do that.
I don't know if that house is still there, though.
No, it's not.
I'm going back a long time.
I don't think it's there.
Probably
The
not.
survey didn't pick it up.
They actually had Edgewood take it down during the 2008 renovation.
Oh, really?
They asked Edgewood. Edgewood removed it.
Is there a motion to continue 2 weeks? Is that?
Yeah, we would continue to our next meeting, which would be October the 11th, which would give you guys an opportunity to get before planning, get their comments to us, and then Lisa's results
Yeah.
You know, the official
We'll make sure you
stuff.
have a full file of that.
A big time?
We'll make sure you have a full file of the comments to me.
Yeah. Right, did I miss anything?
Pardon?
Did I miss anything? I think those would be important. And then we'd have that all by the next meeting.
A motion to continue, Mr. Chair, to October 11th.
Second motion.
Okay, all in favor?
Aye.
Okay, stands continued.
Thank you.
If you guys just signed the form with Merrill, that would be great. And we'll keep this in the file with Merrill.
Thank you very much.
Thank you.
Thank you.
You said we're first on the 11th, is that what you said?
We're gonna, yeah, you know,
Try to get before,
As long as you're in front of Sharon.
I'll do what I can for you there.
You take up this much room at home?
All right, is there anything else on the agenda? Did we miss anything?
What, Kappa?
There's a chapter notice? Okay, there's a chapter notice.
I don't know where it is.
I couldn't find mine.
Really?
You couldn't find yours?
Not in my stuff. What put that? They're so messy.
I didn't find it. You have it?
Dated August the 19th. Has been notified by the owners of affordable unit at Juniper Circle to sell. So, you know, I think these chapter notices, we just need to make sure that they get directed over to the Board of Selectmen. Every time they come in, there's two chapter notices, one dated August the 19th, one dated August the 23rd. So we could send them some kind of official communication from us with the attached notices and just asking them, informing them of what's come in so they can take any appropriate action.
I think they get notification anyways, because the town does have the first right of refusal, so.
It just doesn't say it,
Yeah.
you know, so I just like a paper trail, so. I don't know. So those them. Anything else?
Motion to adjourn?
Motion to adjourn?
Motion to adjourn, Mr. Chair.
All in favor?
Aye.
Stand adjourned.